Yes, please.
Item number 50. I have instruction not to press, Lordship.
50.
50.
In item 50. Heard Mr. H.K. Sharma, learned counsel for the petitioner. Also heard Mr. S. Borwa, learned government counsel for the state respondent. Mr. H.K. Sharma, learned counsel for the petitioner, submits that he has received instructions from the petitioner not to press the instant writ petition and accordingly seeks withdrawal of the same. Stop. In view of the aforesaid endorsement made by the learned counsel for the petitioner, this writ petition stands dismissed on withdrawal. Disposed of.
Lordship, I beg to mention item number 40, Lordship, bail hearing matter.
40.
40, Lordship. CD,
Yes.
CD not received, Lordship.
Petitioner.
Yes, Lordship.
All right. In item 40, await for CD. List again on
On 15th, on 15th, Lordship.
15. Yes.
May I please your
Obliged,
Lordship? Lordship, I beg to mention item number 39 of the daily list, Lordship.
Item number.
39, Lordship.
Yes.
Second concern, Lordship, in this matter, respondent has filed their affidavit. We need some time to file our affidavit in reply, Lordship.
In item number 39, Mr.
N.K. Sharma, Lordship.
Mr. N.K. Sharma, learned counsel for the petitioner, seeks 2 weeks' time to file rejoinder against the affidavit in opposition filed by the state respondent. Stop. Prayer allowed. List after 2 weeks on a date to be fixed by the registry.
Deeply obliged, Lordship.
May I please your Lordship? Lordship, with the consent of
Your
the...
microphones were on nine.
Am I audible,
Yes.
Lordship?
Can you kindly speak a little loud?
Am I audible now, Lordship?
Yes. Not very clear, but yes.
With the consent of the other side, I beg to mention item number 47, Lordship.
Yes.
Your Lordship may kindly allow the...
47 is an order matter.
Lordship.
Please wait for your turn.
May it please, Lordship. Item number 51. Our grievances has been met. So let the matter be closed.
Item
Lordship.
51. Your name?
D. Pathak.
Heard MSD Pathak, learned counsel for the petitioner. Stop. SC Transport. Mr. Goswami appears, no? One. Who appears? Standing counsel Transport.
MD Bora.
MS.
MS
MD. Also heard MD Bora, learned standing counsel Transport. Stop. D. Pathak, learned counsel for the petitioner, submits that the grievances of the petitioner has already been met. Stop. Accordingly, she submits that the matter has become infractious. In view of the aforesaid endorsement made by the learned counsel for the petitioner, this writ petition stands dismissed on being infractious.
Highly obliged.
Disposed of.
Lordship, I beg to mention item number 19, Lordship. Lordship, in this matter also the grievance already met. Lordship, the petitioner doesn't want to place this petition anymore, Lordship.
Item 19. Heard Mr.
S. Sutradhar, Lordship.
S. Sutradhar, learned counsel for the petitioner. Stop. Also heard PNRD standing counsel. Who is there for PNRD? Also heard Mr. S. Datta, learned standing counsel PNRD. Stop. Mr. S. Sutradhar, learned counsel for the petitioner, submits that the grievances of the petitioner has already been met, and accordingly the matter has become infractious. Stop. In view of the aforesaid endorsement, this writ petition stands dismissed on being infractious.
Lordship,
Disposed
I
of.
beg to mention item 30 to 32.
30?
30 to 32, Lordship, it's a serious matter.
30 to 32, yes.
Lordship, in this matter, Lordship, some negotiations are going on between the petitioner and the respondent authorities. So matter may come up after a week, Lordship.
You are Miss
A. Talukdar.
A. Talukdar. MS A. Talukdar, learned counsel for the petitioner, submits that out of court talks are in process, and accordingly she seeks some accommodation in the matter. Prayer is not opposed. List this matter after 3 weeks on a date to be fixed by the registry.
Much obliged, Lordship.
May I please, Your Lordship? I wish to mention item number 38, my lord. With consent of other side, my lord. So matter may be taken after vacation.
30?
38.
Yes.
May be taken after vacation with consent of other side.
You are for?
Petitioner.
As prayed for by Mr.
H.A. Ahmed.
H.A. Ahmed, learned counsel for the petitioner, which is not opposed by the respondent. List this matter after 3 weeks on a date to be fixed by the registry.
And earlier government also directed to file affidavit. They are not till filed.
Yes, next matter.
May I have the Lordship? Lordship, I beg to mention item number 9, Lordship. Item number 9, Lordship. She matter may be taken up after vacation, Lordship. I am for the petitioner.
You are for the petitioner?
Yes, Lordship.
Why not today?
Lordship, we have some difficulties in this.
What is the difficulty? It's a old matter.
So, as my senior instructed to, as my senior has some difficulties, so he will not.
Alright, just wait for some time.
Much.
Let me just have a look at the file because it's a 17 matter. Yes.
Lordship, I beg to mention item number 7, Lordship. In this case, Lordship, cause of action is over, Lordship. The period for 5 years, Lordship, that was already over, Lordship.
So it has become infractious?
Infractious. I am appealing on behalf of B.D. Goswami, Lordship. But, Lordship, if anything is else, Lordship, liberty may be granted, Lordship.
Are you withdrawing? You're not withdrawing, then what liberty will I grant you? Mr. Goswami from behind is nodding his head.
Mr. The fact is, my lord, we have made this submission, my lord, without informing because there is no connection with the clients now. So that is why, my lord, in the event, but the time is over. We challenge in the...
Then, Mr. Goswami, since you are here, please wait. Let me have a look at the file. Just wait for some time.
May I please?
Yes.
I beg to mention item number 29, Lordship.
Item number?
29, Lordship. Matter may be adjourned for the day, Lordship. Senior counsel.
29?
29, Lordship.
What do you want in 29?
Matter may be adjourned for the day, Lordship.
You are for?
Petitioner,
Lordship. As prayed for by Mr. A.B.T. Hawk, learned counsel for the petitioner, which is not opposed by the other side, list this matter after 3 weeks on a date to be fixed by the registry.
May I please your lordship? I beg to mention item number 58.
Order matter.
Admission.
5-8.
Yes.
Supplementary. Yes.
Yes. This item may kindly be taken up at 2 o'clock.
At 2, there is one matter fixed at 2, but anyway, you try your luck. At 2. 58 to at 2. Alright.
Last oblige. May I please your lordship? Lordship, I beg to mention item number 27 for HM.
I'm having a lot of difficulty in hearing this. Some problem with the sound.
Item 27 for HM.
40?
27.
27. Yes, what do you want?
After vacation.
You are for the?
Petitioner.
Have you taken consent from the other side?
Yes, lordship.
As prayed for by MS M. Sharma?
D. Borgohain.
MS?
D. Borgohain.
D. Borgohain, learned counsel for the petitioner, which is not opposed by the other side, list this matter after 3 weeks on a date to be fixed by the registry.
Oblige, lordship. May it please your lordship, I beg to mention item number 33 of the daily list.
33?
Yes, your lordship.
Yes.
Your lordship, similar matters are pending in this. If your lordship allows, this matter may come up tagged along with those matters.
Do you have the citation? Yes, as prayed for by MS?
S. Newar.
S. Newar, learned counsel for the petitioner, list this along with so-and-so, so-and-so, list. Give the list, please.
Oblige, your lordship.
After, on a date, when?
Your lordship, date is not fixed, it is likely to
after
come
2 weeks on a date to be fixed by the registry.
Oblige.
May it please your lordship. I beg to mention item number 12. In this petition, some petitioner has died, and a substitution petition is being filed today. So the matter may be adjourned for today. And
in item 12, you write your name?
S.R.A. Nasir.
Mr. S.I.
S.R.A. Nasir.
Nasir, learned counsel to the petitioner.
Petitioner
submits that a substitution application has been filed today.
Yes.
Stop. However, the same is not on record. Let registry verify and place the same on record. List this matter after 2 weeks on a date to be fixed by the registry.
Highly obliged.
May it please your lordship. Lordship, I beg to mention item number 25, your lordship. Lordship, I am making this mention on behalf of Mr. D. Sahu, your lordship.
Yes.
Today he is out of station, your lordship. I pray
it
that
is submitted by Mr.
KJ Saikia.
KJ Saikia that Mr. D. Sahu, the conducting counsel, is out of station and accordingly seeks some accommodation in the matter with the consent from the other side. Stop. List this matter after prayer allowed. List this matter after 3 weeks on a date to be fixed by the registry.
Obliged.
Call the list, please.
Number 1.
May I please, lordship?
Steps.
Lordship, we have instruction this matter not to press.
Not to press. Mr.
M. Alam.
M. Alam, Learned Counsel for the heard Mr. M. Alam, Learned Counsel for the petitioner. Stop. Also heard Mr.
G. Bordelot.
G. Bordelot, Learned Counsel
Standing
for
Counsel for the Corporation Department.
Learned Standing Counsel,
Corporation Department.
Corporation Department. And caveator is there? Stop. Mr. So and so, Learned Counsel for the petitioner submits that he has received instructions from the petitioner not to press the instant writ petition, and accordingly seeks withdrawal of the same. Stop. Prayer allowed. In view of the prayer allowed, the writ petition stands dismissed on withdrawal. Disposed of. One. None appears for the petitioner when called. Stop. Anybody for the state respondent? MS. So and so is present for the state respondent. Stop. Naam to DD Bob. UDAS, MS UDAS, and then you write. It appears that on the last two occasions, 27 November 2019 and 9/1/2020, also there was no representation on behalf of the petitioner when the matter was called. Stop. In view of the consecutive non-absence of the petitioner on the last three occasions, this list petition stands dismissed for non-prosecution. It will dispose of it.
May it be elected. Here, my lord, I need some accommodation, my lord. So, my lord, I am praying, my lord, to leave the matter after vacation, my lord.
Accommodation on what ground?
My lord, actually, I need some updated instructions from my client, my lord. So, my lord, they have shared a mobile number, my lord. I could not contact them, my lord. So, after
the whole matter,
and
it has come up after a long time. It looks.
Yes, my lord.
All right, let him take. Your name?
Yes, Hawk.
Mr. S. Hawk, Learned Counsel for the petitioner, submits that he may be allowed some time to obtain instruction from his client, as the matter has been listed after almost
2 years, 3 years.
3 years. Stop. Prayer is not objected by Mr. N.C. Das, Learned Senior Counsel, assisted by M.S. J. Bush. Stop.
For respondent number 1 and 2, my lord.
For respondent number 1 and 2, and M.S. U. Das, Learned additional senior government counsel for the state respondent. Stop. Prayer list this matter after 3 weeks.
On 23rd of July, my lord.
When do you want it?
23rd of July.
Or list on 23/7/2024.
Right. Oblige me.
यार आगोर मैटर जो UDAS लिखी सा additional senior governor. That's her designation. Yes, please.
Lordship, the health department has filed an affidavit in opposition.
You want to file a rejoinder? Your name?
D. Dekar.
Mr. D. Dekar, Learned Counsel for the petitioner, seeks 2 weeks' time to file rejoinder to the affidavit in opposition filed by the Health Department. Stop. Prayer is allowed. List this matter after 2 weeks on a date to be fixed by the registry. Yes, Mr. Goswami. I will record your submission that the term is over and close the matter. This is for the...
My lord, the petitioners, my lord, challenge the...
removal?
Not, yes, removal by the government, my lord, but these were elected representatives, whereby virtue of their post, they are officiating members in the board. And we relied on section 29, but anyway, those things have no meaning now.
All right. Mr. B.D. Goswami, Learned Counsel for the petitioner, submits that since the subject term is over, the matter has become infractious. Stop. You are there?
I have for 3 months.
on top you say heard Mr. B.D. Goswami for the petitioner and you thus for the state respondent. And then later you say, in view of the aforesaid endorsement, this writ petition, in view of the aforesaid endorsement made by the learned counsel for the petitioner, this writ petition stands dismissed on being infractious. Disposed of, 7.
May it please your Lordship.
Yes, please.
Lordship, matter relates to non-payment of contractual bill, my lord.
Contractual bill,
Yes,
admitted contractual bill.
Yes, my lord. They have already made a payment of, my lord.
You had filed this in 2017.
Yes, my lord.
Yes. How much have they made payment?
35,000 is outstanding, my lord.
How much is outstanding?
35,000, my lord.
35,000.
Yes, my lord.
Out of 1,45,100.
No, my lord. 4,39,425, my lord.
So the total due was
4,39,425, my lord.
And out of that, 35,000 has been is
Paid,
still
my lord.
pending.
Yes. 35,000 is pending, my lord.
Is pending.
Out of that.
Acha, now where do we get that this 4,39,000 is an admitted amount?
My lord,
Which document?
completion certificate is there, my lord.
Where?
My lord, may peruse it, my lord. Page 14, my lord. Page
But
14.
this say 1,45,000 present bill value, and your prayer also I found it is 1,45,000.
No, my lord. Prayer portion is.
No, but this is 1,45,000, correct?
Yes, sir.
Present bill value.
Yes, sir. It's 7708. Petition you're looking to. That one is different case. This is different. There are two.
You see your representation at page 18?
Yes, my lord. This one is different case, my lord.
1 lakh, huh?
I am having different petition, my lord.
He's referring to another case,
Yes, ma'am.
Lordship. There are two other cases, Lordship.
I have 7708.
7708.
Yes, my lord. I have 407, my lord.
But that is not listed before
Yes,
this
yes,
court.
Yes, Lordship. Yes, Lordship. Above all, Lordship, we don't have instruction.
You don't have instruction.
Yes, Lordship.
No, but is this an admitted amount? Because the completion certificate is signed by the executive engineer, so it is it is already admitted. Then you make the balance payment in terms of Tamsher. I can decide it, isn't it, Ms. Das?
Lordship.
Where is the citation of?
No, I don't have. Otherwise,
have it?
Lordship, we have one decision of this court, Lordship,
Sure.
whereby it said that if there is an arbitration clause,
No, we are not going into the arbitration clause, Ms. Counsel. It's a contractual bill amount which has been kept pending since 2017. Absolutely not done.
that is not Tamsher.
And here it is a disputed fact. Here, this is on a disputed question of fact. This is an admitted fact. Yes, where is the citation of Tamsher Ali? Can you, Mr. Borpujari, can you take it out in your iPad and give it to me? I can borrow your iPad for some time. No. It is reported. Yes, yes, yes. All right. Yes, I've got it. Heard Mr.
S. Upadhyay, my lord.
S. Upadhyay, Learned Counsel for the petitioner. Stop. Also heard MS.
S. Kempray.
S. Kempray, Learned Kempray, Learned Counsel, Learned Standing Counsel. KAC and MSU.
Probably I'm not.
You are not there?
Probably I'm
For the state for the Learned KAC for the state respondent. Stop. By filing this petition under Article 226 of the Constitution of India, the petitioner is seeking payment of rupees 1,45,100 which is outstanding against his contractual bill. Stop. The case of the petitioner is that the petitioner had executed works against work order dated 27/11/2014 issued by the Executive Engineer PWD within bracket R, Boithalangso Division under the respondent number 5. Stop. The amount of such work was fixed at rupees 2,45,564 within bracket words only. After completion of the entrusted works of the Executive Engineer PWD, work completion certificate was issued to the petitioner on 26/12/2014 by the Executive Engineer PWD, certifying that the work has been verified physically by him and found complete by the petitioner in all respect as per satisfaction, drawing and tender agreement. And the bill and further certified rupees 145,100.00 to be the value of the present value of the outstanding bill. Stop. Though representations have been filed to the respondent authorities for release of the aforesaid admitted amount to the applicant, the same having not been done, the present writ petition has been filed. Stop. Heard the parties and perused the materials available on record. It appears that despite certification of the amount in due by the concerned Executive Engineer PWD-R, the bill of the petitioner is pending since 2014. Stop. It is absolutely unfortunate that despite the petitioner has completed the work to the full and final satisfaction of the respondent authorities, his contractual bill has been kept pending till date. This is sheer deprivation of the fundamental right of the petitioner, and this court depreciates such non-action of the respondent authorities in clearing the pending bills of the contractors. Stop. Accordingly, this court is of the considered view that this writ petition can be disposed of with the direction to the respondent authorities. No, just on top you say. Today, when the matter has been called, the petitioner submits that some payment in the meantime has been made and a balance of rupees 35,000.
That instruction I have in this particular case, my lord.
Oh, acha. So here nothing has been.
Nothing.
Dispose of with the direction that the respondent authorities shall dispose of the representation of the petitioner in terms of Tamsher Ali and others versus State of Assam and others, reported in 2008 volume 4 GLT 1 within a period of 2 weeks from today, 3 weeks from today.
Lordship.
From the date of receipt of the certified copy of the order.
Lordship, at least 1 month. 1 month.
All right, 1 month.
I am deeply obliged, my lord.
Disposed of. return corridor. Ms. Campre, take this decision. Disposed of there.
May I please, Lordship?
Yes.
Lordship?
You wanted accommodation in this matter?
Yes, Lordship.
Yes, what was it?
Lordship, in this case, there are 12 bighas of land initially in the name of petition number 1. Petition number 1 is the number 3 Kalipur Shaka Shatra, Lordship. Out of 12 bighas of land, 5 bighas of land offered to a village level water supply project and 2 bighas of land offered to a ME school, Lordship. Lordship, on 9/11/17, Lordship, respondent number 6, Lordship, issued an impugn notice to vacate this land, Lordship. And on 13/12/2017, this Honorable Court stated the matter, Lordship.
The 2017 matter, Ms. Das, no affidavit, nothing has been filed.
Yes, madam. Yes.
What is this going on?
Lordship, may be pleased to grant me, my lord, 3 weeks time, my lord, after vacation, my lord.
This will be the last chance that is going to be granted to you. You have a copy of the petition or not?
We don't have copy, my love. My learned friend will provide me a copy, my love. My learned friend will provide
Give
me
a copy and we shall, this court will give you a fixed date on which date if they don't come up with anything, this court will take up this writ petition. This is the, alright?
Yes, Lordship.
It appears that this matter has been listed after almost 21 it was last listed.
21, Lordship.
Correct. So after almost
3 years.
3 years, stop. It further appears that that the state respondent has not yet filed their return in the matter.
Lordship.
Stop. MS Yudas assures this court, MS Yudas, learned additional senior government advocate, assures this court that that she will take up the matter personally and try to have the return positively filed by the next date of listing.
My lord.
Stop. In view of such assurance, list this matter.
Last week.
July end of date.
Lordship, there is an interim order.
1 second.
30th July. Declare order.
30th July 2024. Stop. Interim, if any, shall continue till the next date of listing.
Much.
Give a copy today itself.
My Lordship, please.
Yes, Mr. Atta?
Yes.
What is this 17 matter?
Yes. We have a tea estate in the district of Kachar. The petitioner company owned a tea estate.
Tea estate.
Vinod Tea Estate. Vinod Tea Estate. In the district of Kachar.
Oh, I think I cannot take this matter.
Oh.
Bajrang Tea.
Bajrang Tea Industries. Perhaps Lordship is not the counsel.
1 second.
Because this is the first matter of that company, Parex.
No, but is this? No, they are different.
Yes, it's Kachar.
No, this is not that.
There is only
No one from Calcutta that is involved in this, right? That Agarwal, Mr.
No, the owner is stationed at Tingshutia.
That's what I've seen.
Yes.
All right.
It's a Binod Nagar Tea Estate at Duarbat in district of Kachar.
Then it's different.
See, in 1980, my lord, we have purchased this land by a deed. Thereafter, that entire land is 3,181.
Affidavits not filed?
My lord, not filed. But my lord, his prayer is, my lord, this is ceiling surplus land. And he wants, my lord, his prayer that either, my lord, it's to reallot in the name of the, my lord, petitioner, his prayer, lordship. So anyway, my lord, we haven't filed any affidavit till date.
Yes, you file it. How will we take this matter if you do not file your pleadings? Have your stand clarified?
My lord.
Right, Mr. Datta, otherwise
yes.
it is of no use. So we'll give you a last chance
because
that may expedite the matter.
By the impugn order, they intended to allot a big chunk of land in favor of a organization, NGO, for other than the purpose of the special cultivation. That cannot be under law. So therefore, there must be a clarification by the government.
You file your stand.
My lord.
This is again of
My lord.
Rakhi. It appears that this matter has been listed after almost 3 years.
Yes.
And further, it appears that no return has been filed till date by the state respondent. Stop. However, MS Udas, learned additional senior government advocate, assures the court that necessary return.
My lord, my learned friend is appearing for revenue department. My lord, probably they must have some say also regarding because.
So I will record both of
My
you,
lord,
MS Udas so and so, and Mr. A. Borwa, Bhattacharya, learned standing counsel revenue, assures the court that necessary return, that necessary affidavits in opposition shall be filed in the matter positively by the next date of listing. Stop. In view of the aforesaid endorsement, list this matter. Yes, when?
On 22nd or 23rd
My
July.
lord, last because we were having my lord vacation. My lord, last week of as my lord 38 or my lord
30th? Or you want?
Or August first week.
Yes, first week August.
My
Give a
lord,
date.
deeply. Any
Give a
date,
date.
my lord, we have.
On 2nd, Mr. Datta, is it are you comfortable on 2nd August?
5th August.
5th August. 5/8/2024. Stop. On top, you please mention, heard Mr. B. Datta, learned senior counsel, assisted by Mr.
J. Das.
J. Das, learned counsel for the petitioners. Also heard MS U. Das, additional senior government advocate, and Mr. A. Bhattacharya, right?
Bhattacharya.
Standing counsel revenue.
My lord, obliged.
Interim order.
Interim, if any, shall continue till the next date of listing.
Lord.
Ex gratia.
In this case, my lord, the finance department has filed an affidavit where they have said that the ex gratia scheme meant for those who are in service, the police service or army, who are deployed in emergency service will be covered. But his case was something different. His son, who was a school teacher, was abducted, and he was killed by extremists.
He is not covered under the scheme.
But then he has to be heard. He's on legs at the moment. Can it be taken up some other day, man?
My lord, petitioner is 86 years old lady, man.
All right,
She is
call him.
bedridden
I'll
now.
keep it. Okay. Wait for some time. All up pisot, huh? Is item 13. None appears for the petitioner when the matter is called. Stop. Anyone for the government? None appears for the respondent also when the matter is called. List this matter on Friday with the remark for dismissal.
Lordship, I am for the respondent
I
number.
know. Where is the petitioner?
Lordship.
No response has been filed in this matter also.
Lordship. Affidavit no position not filed.
None
Lordship, it is an appeal that is arising out of an appeal, revenue appeal.
None appears for the petitioner when the matter is called. Stop. Mr. S.B. Raman.
No, Lordship, I am for the R.K. Bhuya.
And Mr. R.K. Bhuya, learned counsel for the
Respondent number 4 to 6.
Respondent number 4 to 6, and MS Udas, learned additional senior government advocate for the state respondent are present. Stop. List this matter on Friday with the remark for dismissal. Yes, Mr. Day.
On the last occasion, because I was stuck in traffic. Here,
All right. In this matter, what about the affidavits, returns?
my lord, in fact, this is listed after a long time. My lord, in the meantime, I have found, my lord, the
Not
card.
long time. It was listed on 19th June, on which date perhaps you were not there.
My junior colleague was there, my lord. I'm not on the last occasion, but
No, but be that as it may, you want some time to file?
in fact, I have to reconstruct the file, my lord, because the earlier standing counsel did not hand over me the
All
file.
right. This matter is listed today with remark within courts for dismissal, since there was no representation on the last occasion on behalf of the petitioner. Stop. Today, when the matter is called, Mr. R. Day, learned counsel for the petitioner, is present. Stop. Yes, Mr.
S.K. Talukdar.
S.K. Talukdar, learned, you are appearing as a standing counsel. Learned standing counsel.
1, 2, 3, 1. Respondent
Standing
one.
counsel what?
Corporation Department.
Standing counsel, Corporation Department. In bracket respondent numbers 1, 2, 3 submits that since the writ petition pertains to 2019, when he was not representing the said department, the concerned file is not available with him, and accordingly seeks accommodation in the matter to enable him to reconstruct the records of the case. Stop. Prayer is allowed. List this matter. Yes, give a date.
After vacation, my lord, in the month of August, your lordship can fix it, my lord. First week of August.
Any date in August. On 19th, Mr. Day, 19/8/2024. Stop. Needless to clarify that since the matter pertains to 2019, the respondents, if they desire, may file their affidavit in opposition before the next date of listing, failing which the matter shall be proceeded in accordance with merit, in accordance with law.
Item 16.
Yes.
May I please your lordship? Lordship, my apologies. Due to
Mr. Talukdar, in this matter also you want...
I am for the private respondent, my lord.
You have the file?
I have the file.
Yes, Ms. Das. Affidavits, nothing is filed.
My lord, I'm again sorry, my lord.
This matter is listed today with remark for dismissal, since there was no representation on behalf of the petitioner on the last occasion. Stop. Today, when the matter is called MS,
Mr. A.R. Bhuya. I'm A. Bora.
MS A. Bora, learned counsel, is present on behalf of the petitioner. Stop.
Yes.
MS U. Das, learned additional senior government advocate, submits that she may be allowed last chance to file necessary return in the matter. Stop. Prayer is not opposed. List this matter first week of July on such and such date. August.
Not August.
It's a question of law, my lord. In fact, he is seeking, my lord, that he is immune.
You file whatever you have to file.
It's a question of, my lord,
You see,
yes.
Mr. Talukdar, you can't be taking them by way of a surprise.
No, my lord.
So
It's a legal point.
Whatever your objection, put it in by way of an affidavit.
Correct. In fact, I will...
Let's not change the
I will
basic
rely on-
protocols of the pleadings.
No, I rely on their documents, my lord. Yes.
But it is always advisable that you file your return.
Oblige.
May it please also. Well, perhaps this matter has been in practice, my lord. I may allow some time to take an
Sorry?
inspection. Well, perhaps this matter become in inspection. But I have to take...
Your name?
My lord, one thing, my lord. I have to just take an instruction 1 week time maybe given.
No, I have understood your name.
S. Rahman.
Mr. S. Rahman, learned counsel for the petitioner, submits that he may be allowed some accommodation in the matter to obtain instruction from his client as regards whether anything is surviving in the writ petition. Stop. Prayer is not opposed. List this matter August 1st week on such and such date.
Obliged. May I please, Your Lordship? Matter pertains to, my lord, compensation of land and Zirat, my lord.
Compensation?
Yes, my lord. The high voltage transmission line was constructed over the petitioner's land. Some towers were constructed and overhead transmission line has been constructed.
No returns have been filed in this matter.
Yeah, please, Your Lordship. I am appearing on behalf of R.B. Mora. She is on election code 1. Kindly pass over the matter for time being. She will appear in this matter.
Who is the concerned department who has to file the affidavit?
My lord.
Who had acquired the land?
My lord, the Power Grid Corporation.
Ms. Bora is appearing for Power Grid?
BTC.
After some time.
BTC is not. Well, BTC is not party, my lord.
For Power Grid, who appears?
Power K. Fukon, my lord. Mrs. K. Fukon was appearing. It is not party, my lord, here.
BTAD is there. What are you saying?
My lord, no, my lord. BTC
Deputy Commissioner Baksha, BTAD.
Oh, my lord, Deputy Commissioner, yes.
Then?
My lord,
you are the petitioner.
My lord,
You should be aware.
The government was appeared.
Mr. Counsel, please do not make submissions unnecessarily to the court. The time of this court is very valuable. Yes?
She is praying for time on behalf of Mr. Aditya Murabha. You have to sometime or my lord because we don't have instruction.
You call for Ms. Fukan and we will take it up when both the counsels are there. After some time. Yes.
Oblige me.
We may be allowed some time to file affidavit, my lord. This
professional fees.
Otherwise, Your Lordship may have a glance at page number 14. The amount was already sanctioned, Your Lordship.
My lord, some I have
it has only
seen
not been transferred into our account.
I have seen, my lord, some.
Earlier, this court has granted some.
One, yes, that one was already, my lord. One
regarding
crore
a different
department.
department.
My lord. So
this is regarding a different
we
department.
may be allowed some time, my lord, to file our, my lord.
You have not filed anything.
No, my lord. Probably I haven't filed because in our file nothing. We
It's
have
a matter of
some
2022. Anyway, let her file, Mr.
No, my
Thakur.
lord.
MSU thus, learned additional senior government advocate assures that necessary return in this matter shall be positively filed by the next date of listing. Stop. In view of the aforesaid endorsement made by the learned additional senior government advocate, list this matter first week August?
My lord.
First week of August on such and such date. Stop. Next, needless to clarify that since the matter relates to non-payment of professional fees of the petitioner, who is a practice of the petitioner pending since 2018, correct?
Lordship.
Pending since 2018, if returns are not submitted by the next date of listing, the writ petition shall be taken up for disposal on its own merits. All right. File what whoever wants to file can file the returns by the next date. Yes.
Please, Your Lordship. I am appearing on behalf of my Lordship.
Hmm?
I pray for adjournment for day, Lordship.
My Lord, in this case, my Lord, many adjournments were taken by the petitioner, my Lord. Actually, the writ petition itself is not maintainable. It relies
You
upon...
want for one day.
For today, Lordship.
For one day. When do you want it?
After vacation immediately.
No, my Lord, no vacation, my Lord.
One day and
One
now
day
after
cannot be.
vacation, what is this?
Day after tomorrow, Lordship.
All right. as requested on behalf of
P. Sharma.
Mr. P. Sharma, learned counsel for the petitioner, list this matter again on Wednesday, such and such date. (21 and 22) na ito? None appears on behalf of the petitioner when called. List this matter on Friday with remark for dismissal. Date to be given Friday. Day. Rakhi, what Friday bli koisu ba Wednesday koisu. Don't say the day. You say the date. Date of Friday. Yes. None appears for the petitioner when the matter is called. List this matter again on Friday with the remark for dismissal.
26.
8 to 24, isn't it? None appears for the petitioner when the matter is called. Stop. It appears that on the last two occasions, I 12/8/2022 and 27/5/2024, also there was no representation on behalf of the petitioner when the matter was called. Stop. In view of the consecutive non-representation of the petitioner, are you appearing in this matter?
No.
In view of the consecutive non-representation of the petitioner, in view of no representation, consecutive no representation on behalf of the petitioner, this court is of the considered view that this petition can be dismissed for non-prosecution. Ordered accordingly. On top, you say Mr. N. Goswami, learned government advocate, is present for the state respondent. Disposed of.
Very please, earlier one series of petitions in connection with this matter has been disposed of by this honorable court.
What is the issue?
Matter relates to establishment charge demanded by the excise department to the licensee.
Anyone appearing for the respondents?
Mr. P.N. Goswami used to appear.
Mr. P.N. Goswami appears? I think there is some...
Yes.
So, Mr. Pathak is here. On the last occasion he had appeared. Excise, right?
Yes, madam.
Alright, then if Mr. Pathak comes, we can dispose of you. Wait for some time. Mr. Goswami, can you call for Mr. K.B. Pathak? Next.
On 24 minutes, I couldn't be present. Can it be on Wednesday? Because during the pendency of the petition.
You are for the?
I am for respondent number 4. They were under the apprehension that their market will be
One second, item 24 to key order dismissed. The petitioner didn't appear.
He has informed me for some medical reason he could not come. I was supposed to pray on his behalf too.
24 matter.
On Wednesday it can be closed.
As prayed for list on Wednesday.
I am ready.
24 to
26.
May I please? In this case, Your Lordship, I have to take some instruction, Your Lordship, because...
all right. Your Mr.
N.N. Upadhyay.
Heard Mr. N.N. Upadhyay, learned counsel for the petitioner, submits that he may be allowed that he may be allowed some time. Submits that some accommodation may be granted for obtaining instruction from his client. Stop. Prayer is not opposed. List this matter after 3 weeks on a date to be fixed by the registrar.
I am for 6 and 7 months.
All right.
May I please, Your Worship?
In this case, Your Lordship, respondent side
Yes,
filed an
returns
affidavit in opposition
has been filed.
Yes, Lordship. And
you will file a reply.
Lordship, they have already accorded sanction in favor of the next of kin, that is petitioner, Your Lordship. So they are waiting for this.
Ms. Das,
We have sent the proposal to the government, Lordship.
which is the relevant portion in your affidavit?
Yes, sir. Annexure
At page 40, Your Lordship.
40, Lordship.
Annexure.
So your writ petition was the ex gratia.
Yes, Lordship. Husband of the petitioner had.
So this has already been allowed.
Yes, but yet not disbursed.
Yes.
So then we can close this matter.
Yes, Lordship.
It says payment of ex gratia amount will be made subject to the availability of fund. That we will not.
Yes,
we will fix at time. All right.
Yes.
Your next of kin certificate is here.
Yes, Lordship. At page 60.
Page 6.
16. 16, 16. Of writ petition. One is wife.
How are you related?
Petitioner number 1 is the wife and 2 is the son of the deceased.
All right. This is for disposal. Heard, Mr.
S.I. Akan.
S.I. Akan.
Yes.
Learned Counsel for the petitioner. Stop. Also heard MSA
S. Borwa.
S. Borwa, learned government
Government
advocate for the state respondent, and MS N. Borderloy, learned standing counsel, revenue. Revenue. Stop. By filing the instant petition under Article 226 of the Constitution of India, comma, the petitioner and the petitioners are seeking direction for releasing an amount of rupees 2 lakhs as ex gratia relief against the death of late Narendra Nath Borwa, alias Naren Nath Borwa, i.e. husband stroke father of the petitioners, as per the government notification dated 15/11/2014 issued by Government of Assam, Revenue, within bracket, Relief and Rehabilitation Branch and Disaster Management Department, Dispur, Guwahati 2000-06. Stop. Heard the parties and perused the materials available on record. Stop. It appears that the petitioners, it appears from the next of kin certificate enclosed as Annexure 3 to the writ petition that the petitioners are the wife and son respectively of late Narendra Nath Borwa stroke deceased. Stop. It further appears from the affidavit in opposition filed on behalf of the respondent number 3 on 7/3/2024 that
29 February. Lawsuit affidavit in opposition filed on 29 February.
That the District Commissioner cum Chairman DDMA, Bojali on 17/10/2023, after perusing the report submitted by the jurisdictional circle officer and the jurisdictional superintendent of police and post-mortem report, comma, and on being satisfied, comma, sanctioned rupees 2 lakhs as ex gratia in favor of the petitioner. Who is petitioners? Barsha Borwa is the wife.
Yes.
In favor of the petitioner number 1, comma, next of kin of the deceased who died on 3/8/2017 due to road accident under Bojali Revenue Circle, Pacharkuchi, as per the prescribed format. Stop. It further appears that the copy of the said order is forwarded to the Revenue and Disaster Management within bracket RR Department, Government of Assam, for taking necessary action to release the sanction amount. Stop. Paragraph 3 of the aforesaid affidavit in opposition is reproduced hereunder for ready reference. Page 38 of probably. Next paragraph. In view of the aforesaid sanction, comma, this court is of the considered view that this writ petition can be disposed of with a direction to the respondents to release the sanction amount.
Respondent number 1.
To respondent number 1.
Yes.
To release the sanction amount within a period of 2 months from the date of receipt of the certified copy of the order. Stop. Respondent number 1 will release.
Yes. Yes, okay. There's shortage of fund, that's why.
That's all right, but you see, non-availability of a fund cannot be a ground for non-release. So, it's a welfare state; it has to arrange. Accordingly, writ petition stands disposed of.
Replay.
Into 35. Huh? Disposed of. Yes.
May I pray, madam? In this case, I am led by senior Mr. Kihan Chaudhary. He is on the way. Can it be taken after some time? He is coming.
Affidavits and everything has been filed.
Yes, yes.
I have filed.
All of this. Yes. Yes.
Respondent number, please file affidavit, my lord. I have also
Sorry?
filed the reply, my lord.
You want to file a reply?
Already filed.
You filed?
My
Yes.
Matter pertains to, my lord, demarcation of land.
Yes,
my lord.
BTC. Right, we'll have it on another date then.
My lord, after vacation.
It appears that pleadings are complete in the matter. Stop. Mr. K.R. Padgiri, learned counsel for the petitioner, is present. However, there is no representation on behalf of the BTC. Within bracket, respondent number 3-5. Stop. Let this list again on list after 2 weeks on a date to be fixed by the registry.
My lord, oblige.
Service is complete?
Yes. In fact, in earlier,
I've seen 9/1/19 order.
Yes. It has to come in the admission column.
So why is it today then in orders?
Government has not responded.
No, actually, though there are 5 respondents,
Yes.
and I think no wakalatnama has been received from R5 till date. But otherwise, R5 has been served, right?
Yes, yes. Municipal board. Our difficulty is this: in our land there is a big dumping ground. All waste products of the town that was dumped.
This court is not going to wait for anyone. If they don't want to be represented, this court cannot force them, right? But only thing, who is the concerned authority who has to file the affidavit?
Deputy Commissioner, because
Deputy Commissioner?
Deputy Commissioner Pinshukya.
Yes, government, Mr. Borwa. It's a 2018 matter.
If you know
Yes, Lordship, in 2018 only an instruction has received. So whereby it has been reported that inspection has been done over the land, and for continuous 24 years, municipal authority have been using it as a dumping ground. And said there was no dispute, no
That
resentment
doesn't mean that they will continue using the petitioner's land as a dumping ground.
Yes,
illegality cannot be perpetuated.
Finally, the Deputy Commissioner has come to a conclusion that in terms with Rule 116 of the settlement rules, that land has been, that pata has been striked out. So this is what the instructions
How
say.
it can be just
So there
struck
is a
down like that? There must be some procedure. Any procedure has been followed, Mr. Datta?
Unless we abandon the land, my interest.
There has to be some procedure. Has the procedure been followed?
No,
Otherwise, there is clear infringement of the constitutional and human right of the petitioner over the land.
No, the petitioner doesn't claims any possession over the land. There was.
Then, Mr. Burwa, I think you file an affidavit.
I think we'll require up-to-date instruction.
Correct. You obtain an up-to-date instruction in the matter and file your return, giving them a chance. Mr. Datta, I think it will be appropriate.
Yes.
This matter cannot be disposed in this fashion.
Fixed it.
Mr. S. Borwa, Learned Government Counsel for the State Respondent, assures that submits that though instructions has been received way back in
2018
in the year 2018, however, up-to-date instruction is required to file the return in the matter. Stop. Prayer is allowed. List this matter
on 5th of August,
on 5/8/2024. Stop. Needless to clarify that since the matter pertains to 2018, in the event no return is filed on the next date of listing, the writ petition shall proceed in accordance with law.
Grateful.
My Lord, the item 58 has been, my Lord, somebody mentioned, my Lord, wrongly, that may be taken up, both sides are there, my Lord. Item 58, admission matter.
Item?
58, admission matter.
58?
58.
Yes, in the, no, I think we did not grant them the...
My Lord, somebody mentioned for 2, my Lord.
Yes, at 2.
But we are
that is a wrong mentioning.
No, my Lord, without informing me, my Lord, mentioned.
I don't know who mentioned it.
We are, both sides are ready, my Lord. It can be taken up.
So only you both are there?
Yes.
No one else?
No.
Are you sure?
Yes.
How come someone just made a mention?
My Lord, some mistake, my Lord, was there.
Anyway, item 58. Okay, admission hoi gol no? Electricity bill, not paid.
My Lord, by virtue of the interim order, 30% has been paid. But here, your Lordship, my Lord, first thing, 2 law points, my Lord, I am placing. Your Lordship may just take up section 126 of the Electricity Act.
Then we'll fix it for hearing, admitted. Will it take time or?
My Lord,
otherwise the issue is covered here.
All right, Electricity Act.
Yes.
Because there are judgments of the coordinate benches and division bench which say that these appeals have to be first heard by the appellate authority under 127. So then...
One second.
Yes,
let me understand first. You are referring to?
126 subsection 3, my Lord.
Of the Electricity Supply Act?
Yes, Electricity Act.
Electricity
Act.
Economy.
Electricity Act 2003. I have another copy, my Lord. I can. subsection 3, my lord.
I'm going to flag mark your copy.
Yes, my lord, no problem. No problem.
Section 126.
126.
Yes, please.
Subsection 2 may be said.
Yes,
the order
please.
of provisional assessment shall be served upon the person in occupation or position in charge in place of premises in
So
such
the
manner.
provisional assessment has to be served.
Served. Then, my lord, 3. The person on whom an order has been served under subsection 2 shall be entitled to file objection, if any, against the provisional assessment before the assessing officer, who shall, after affording a reasonable opportunity of hearing such person, pass a final order of assessment within 30 days. My lord, this is the mandatory provision. 30 days, my lord, he has to pass it from the date of service of such provisional assessment order of the electricity charges payable by such person.
No,
Here-
but in your case,
my lord,
though
the
the notice is given, but it was not disposed of within 30 days.
No, well, no.
Then?
Yes. Here, provisional assessment order was served on 11/3/16, my lord. Your losses may just see 11/3/16.
16.
Page 62/63.
This is the provisional order.
Provisional assessment order, as per subsection 2.
Yes.
62, your losses may just see, my lord.
Yes.
11/3/2016. Now the final order has been passed on 73, page 73.
73. Yes.
My lord.
16/6/16.
16/6/16. It is more than 3 months, my lord. 1 month they have to pass it.
How are you prejudiced?
No, my lord, this is mandatory provision, my lord. This provision.
Provisions are procedural.
No, question of my lord, that does not arise, my lord. I'm just submitting, my lord, to judgments of this two high courts, my lord.
Mrs. Ayawala, this court is only concerned with a 30 days period, correct?
Yes.
According to you, that is a mandatory
Yes.
requirement. Non-following of that will make the will vitiate the order. This is what is your
This is
submission.
first point, my lord. This is the
First point.
First point. And
Where
it is-
this court is posing the question to you that is this, because it appears that this is procedural.
Yes.
Correct? Now, disposing it within the 30 days
Yes.
perhaps will not cause any prejudice. Because you have got the opportunity, you have...
My lord, sometimes, my lord, the question of it is a mandatory, my lord, provision.
Anyway, show me what authority you are carrying.
My lord, yes. My lord, just I am giving Delhi High Court.
Rupak.
my lord.
Pathai dia, Manjana pathai dia. Mr. Pathak, this is 1989 180 ITR 280.
Hey, copy is not there, this way.
Internet reception is a little.
What do you want to show from here?
My lord, yes.
This is a division bench,
Yes,
Delhi
sir.
High Court.
Yes. Division bench. Division bench. Para 6, my lord, if your lawsuit finds, my lord, in our opinion, the decision of the tribunal is correct when it is stated that the effect of holding that the assessment was barred by time is that all further posting pursuant to the said decision would be infructuous. In case of the guest jurisdiction to pass an assessment order, if it is within limitation. If the assessment order is barred,
If it is within limitation, you are trying to read that 30 days.
30 days.
30 days is the prescribed time. So if you have to pass the order, it has to be within 30 days.
my lord. This is another judgment is there, my lord, Allahabad High Court also.
But in this case, it is relating to an income tax,
Income
correct?
tax,
What is
my
the
lord,
provision? Where do I
yes,
get the provision? Is it quoted in the order?
Yes. Yes. Income tax section. I'm
Because
just giving.
decision has to be understood in the context it is given. This is under section 254(2) of the IT
Yes,
Act,
right.
correct? What is that provision? You have
My
a
lord, just
provision.
your lordship. I have one copy, my lord. I just
You may read it.
my lord. the appellate tribunal may at any time within 6 months from the end of the month in which the order was passed with a view to rectifying any mistake apparent on the record, amend any order passed by it under subsection 1 and shall make such assessment if mistake is brought to notice by the assessing officer, provided that amendment has which has the effect of assessment or reduce the fund.
This is relating to an appeal.
Yes, my lord.
Correct?
Yes. So 6 months, my lord, it has been changed. Appellate tribunal may that mistake will be 6 months.
This is relating to a adjudicating process.
This is
Is
also,
it?
my lord, this is
No,
also
I'm asking you the...
yes.
Correct?
Yes, here also it is executing, my lord, because they have to issue...
Here, adjudicating in the sense, here it is the bill.
Bill.
Which has been revised.
Right.
Correct?
Bill, my lord, first provisional assessment bill is given, then we have to file objection and they have to hear it, us.
All right. Did you get a copy of this?
Yes.
There is another Allahabad. Jana judgment, my lord, this is Allahabad High Court.
Sharmila, come. No, judgment. Okay, site ki bari pada. Yes, please.
My lord, para 12.
Para 12.
Yes.
Yes.
We do not find any exception under the Act where period of limitation for passing an assessment order.
This assessment is under which Act?
This is also income tax.
Income tax. Okay. Assessment order can be enlarged or enhanced. It cannot be, isn't it? No exception for that.
That is about 12, 13 and 16.
Okay.
14. 14 is also there, my lord.
12, 13 and 14. All right.
Now, this is the first point, my lord, here in court.
Okay.
Second point, my lord, I am coming. No. 126.5, my lord, your lordship.
126, subsection 5?
5 also.
Yes.
If the assessing officer reaches to the conclusion that unauthorized use of electricity has taken place, the assessment shall be made for the entire period during which such unauthorized use of electricity has taken place. And if, however, the period during which such unauthorized use of electricity has taken place cannot be ascertained, such period shall be limited to a period of 12 months immediately from the so-and-so.
What does
my lord,
this
here
mean?
what happened, my lord? Petitioner has an industry. My lord, he has a connected load. There was some extra space also and extra connected load. My lord, he issued an advertisement for giving on rent, my lord, some of the places. And thereafter, my lord, on the advertisement, some parties approached them and they have entered into an agreement. My lord, just your lordships may see, my lord, some paragraph.
Just one sec. If the assessing officer reaches to the conclusion that unauthorized use of evidence has taken place, then shall be made for the entire period during which such unauthorized use of electricity has taken place. And if however the period... So therefore, if in case of any unauthorized use, then the assessment has to be for the whole period.
The period for which unauthorized use is there. If that cannot be ascertained, then it extends to 12 months. My lord, here your losses may just come to page 15 of my applicants.
Page?
Page 15.
Yes.
14 and 15.
Yes, these are advertisements.
Two advertisements, my lord.
Gudam at Beltola.
29th January 2016, my lord, and 15th,
Yes.
5 to 16.
Gudam at Beltola.
Yes.
Okay.
5 to 16.
So according to you, this has been unauthorizedly done.
Unauthorizedly, my lord, what happened? We have applied for change of the connection load, my lord. But that was not done, so it may be unauthorized, my lord. But the thing is this, unauthorized for which period I can be charged. Now, the parties had entered into agreement after this advertisement, they came, and page 18, your lordships may see.
Is there any remedy under the Act against such provisional assessment orders?
Provisional assessment, well, the final assessment order was passed.
So against that there is no appeal or anything provided?
There is an appeal, but no authority was there, my lord.
Have you stated that in your pleadings?
Yes. Now, you will also find, my lord, the agreements were entered into 15 February 2016.
Yes, page 18, right?
Page 18 onwards, my lord, several agreements are there.
As regards this second submission of yours, which
Yes.
are the relevant paragraphs in your petition?
Yes.
Just give me the number.
My lord, page 9, Roman 7, my lord.
Para Roman 7?
Also.
Okay.
Yes.
All right. And the agreement starts from
There are
page
3 and
8.
5 also there, my lord. Actually, pair 3 and 5 is there. And this is the submission, my lord.
3 and?
3 and 5.
Okay.
Actually.
And page 18 onwards, the agreement.
Yes, my lord. So, the agreements are there. These were, my lord, it can be ascertained, my lord, when they were given on rent, my lord.
All right.
So, when the this inspection was made, my lord, on 6/5/2016.
Yes.
That is at page 57, my lord.
Page
57. As per this inspection report, my lord.
This is what? Inspection?
Yes, my lord. There they say, my lord, that we have given some connection to non-industry purposes.
Where do you find that?
Page 57, my lord. Your
Yes,
lordship-
I am at page 57. Where
Yes.
is that particular
Yes, my lord.
finding?
Your lordship at page 58, my lord.
Mrs. Havela, which part, that
Yes.
particular finding, which you just read?
If your lordship find, my lord, the
Serial number?
A, B, C, D, my lord, that they have said. Now,
You are referring to the inspection report of the APDCL at page 57, correct?
Yes. Here, my lord, first, my lord, they have found Eden Low cold storage. My lord, the Rabs Cordon, my lord, they have shown.
Rabs
Cordon. Well, this is, my lord, separate. Now, fabrication industry, bakery cordon, my lord.
Which one?
Bakery cordon H, my lord.
H. Bakery go down. Yes.
So,
but you just read.
then
this is
next
something
page,
different.
furniture cordon.
Huh?
Next page, furniture cordon.
Furniture.
So these are, my lord,
All right. What you were reading is at page 59, serial number 23.
Yes.
The consumer running with HT industry but commercial category load found here, Godam.
Yes.
Any 5 to be taken accordingly as per so and so. What does this mean?
So they say that some physical inspection, my lord, some godowns have been given the electricity, my lord, which are not industry. Although under micro, my lord, that act, my lord, it has been declared as industry.
All right.
So now they have charged, my lord, for the entire connected load and for the entire period. 12 months. 12 months they cannot do it, my lord. As per 126.5, when it is ascertained that we have given it on February, my lord.
Only for that
Only
period.
for that period, my lord.
Okay.
And that too, only for the load for which, my lord, commercial use is there, because I am relying on, my lord, this
So your arguments are twofold. Number one, that it is
threefold, my lord.
Huh?
Threefold.
So there is a third argument.
Third argument is, my lord, second argument is limited for the period. That is 126.5.
No, first is that.
First is, my lord, 126.3.
Correct.
Second is 126.5.
Right.
That limited period.
Right.
Third is, my lord, they can charge only for the load which is given to non-industrial purpose.
For the load.
Load. For non-industrial purpose. Industrial purpose, my lord, which I am utilizing, that cannot be penalized. I cannot be penalized. Only the load which I have given to the godons, that can only be penalized.
So basically the second to limb of your arguments relates to the manner in which the bill has been raised.
Yes.
According to you, it is not in terms of the Act, correct provision. This is your basic.
In this aspect, my lord, I am just relying Assam Electricity Regulatory Commission Supply Regulation 2017.
Perhaps those regulations will not apply to this.
Mr. Pathak, you will get your turn. Yes. What do you want to show from here?
The period of assessment, my lord, that has been shown. In the assessing officer research conclusion, the unauthorized use of electricity taken place in keeping the provisions of 126(5) of the Act. He shall take in account the following and arrive at the actual period of duration of unauthorized use of electricity to the extent possible. The period from the date of previous inspection, if any, licensing officer, date of detection. Period from the date of service connection to the date of detection. Period of date of service connection. Whenever electronic meters are installed, the load so and so. Based on the valid documents produced by the accused persons, if during the period such unauthorized use of electricity taken place, cannot be ascertained as above, such period shall be limited period of 12 months. This is 126(5) my lord, same, my lord. So, here two things are there. Based on the valid documents produced by the accused persons. We have produced the documents, and they inspection found it, my lord, that this much power has been used for commercial purpose. So only I can be charged for that purpose, and for the duration for which this has been.
So according to you, you can be only charged for the commercial purpose.
Commercial purpose.
For that period.
For that period only, not for 12 months.
For the concerned period.
Yes.
And here you have been charged on
industrial load for 12 months.
For industrial purpose.
Okay. For commercial purpose. And
no, the assessment order is for commercial purpose or
commercial purpose.
They have done.
And their load. And for 12 months.
All right. Let us hear Mr. Pathak then.
Another affidavit has been filed also, my lord, showing that under the micro, that I am not. Your lordship may just see, my lord, an affidavit has been filed here, additional affidavit on 7/6/24.
7/6/24.
24.
I don't think that is on record.
Okay. Anyway, my lord.
Affidavit.
Not
you may have my copy. Additional affidavit on
7/6/24.
7/6/24. By respondent? By petitioner or by respondent?
By petitioner.
It will be additional affidavit. Additional affidavit dated 7/6/24. Petitioner.
Have my copy.
You have a copy?
This is
extra copy?
No, this is not an extra copy. I have it scanned here.
Dani page, my lord, is there from 134 onwards.
Yes.
My lord, 11 page, my lord, you also see the notification page 140. 140.
Yes.
This is a notification, my lord, issued under the MSME Act, my lord. This is issued under MSME Act. Here, my lord, Roman 4,
warehouse, Godam and cold storage.
These are also treated as manufacturing.
As?
Manufacturing activity. Categorization activity under manufacture of
so that it will become industry?
Yes. That will be industry. As per
so Godam is industry?
Industry.
Then there is no
manufacturing, yes.
So then that argument of yours doesn't stand, second argument. That is not for unauthorized. Yes. If it is not unauthorized, then subsection 5 will not come into play. Correct?
Yes.
Have I understood it correctly?
Yes, ma'am.
Yes, please. Are you anything more? All right,
No,
Mr. Pathak.
Completion.
Before
Yeah,
coming
that's
to
a small
the
clip.
facts, Your Lordship, I will give Your Lordship the legal framework under which this matter rests, Your Lordship. Lordship, under the Electricity Act, when a consumer indulges in unauthorized use of electricity, then initially when the unauthorized use is detected under section 126, there is a requirement for doing a provisional assessment. And against that provisional assessment, the consumer has a chance of filing an objection before the assessing officer, who then has to hear him and then pass a final.
First, before doing provisional, there is
Inspection.
So first inspection. Then,
upon detection of unauthorized use, provisional assessment of electricity.
Yes.
Electricity charges payable. Then the consumer has a chance to file objections against the provisional assessment.
that is why that 30 days.
That is that 30 days. And then after hearing him, then the final assessment order is to be passed. And
Here
again,
it was passed after 3 months.
here it was passed after 3 months after hearing.
Have they filed objection?
They had filed objections, they were heard, and
That objection is on record.
It is on record.
Page.
they had filed 3 objections. The first was filed on 30/3/2016.
On
30/3/2016.
3316.
Page 67. The second objection was filed on 12/4/2016, page 68. And the third objection was filed on 25/4/2016, page 70.
Yes.
So,
and after final assessment,
there is an appellate authority,
Where?
section 127. Any person aggrieved by a final order made under section 126 may, within 30 days of the said order, prefer an appeal in such form, verified in such manner, and be accompanied by such fee as may be prescribed by the State Commission to an appellate authority as may be prescribed. No appeal against an order of assessment under subsection 1 shall be entertained unless an amount equal to half of the assessed amount.
this is not done.
They have not preferred an appeal. Now, this position of law, whether a writ petition is maintainable before going to the facts, Your Lordship, whether a writ petition is maintainable at all without approaching the appellate authority, unless a purely legal jurisdictional issue is raised,
Or if a natural justice violation is there.
In fact, regarding the issue of natural justice also, the division bench held, even issues of due process can be decided by the...
No, but here they have been given the due opportunity.
Yes.
There cannot
No,
be
there cannot be.
case of violation
No.
of NJ here.
No.
Right.
No. But
Because the arguments, if you have heard, number 1 relates to that 30 days.
Yes.
According to them, it is imperative on you to pass the order within 30 days. If you pass it after 30 days,
regarding that argument, Your Lordship, I could not find it in the pleadings, Your Lordship. So I was a little taken by
it's
surprise.
a legal argument.
Yes, but I was a little taken by surprise, Your Lordship, because unless I may be wrong, but
now these 3 objections that they have filed is within 30 days.
The provisional assessment was passed on 15/3/2016. The first objection, Your Lordship, was filed on 30/3/2016.
Within. And the second?
Second was filed on 12/4/2016.
Within.
3 days prior to expiry of the 30
third?
days. The third was filed on 25/4/2016.
After.
Where is that representation?
All the
objection.
The first one, Your Lordship will find.
No, the third one.
The third one, Your Lordship will find at page number 70, Your Lordship.
70.
70.
Yes, please read.
25/4/2016 to the area manager. He is the assessing officer, Your Lordship. Dear Madam, further to the discussion on the subject above, the date of purchase the stamp paper is raised. The stamp paper was purchased on 16/2016 by a lawyer to execute all the agreements together after all the spaces were let out. Although the dates of agreement are different with the tenants, they were executed by the lawyer on the same day.
All right. And the previous one is at page 68.
Previous one is at page number 68, Your Lordship. Of 12/4/2016.
And before that is 33.
33, page 67, Your Lordship.
And the provisional assessment order
is at page number 64, Your Lordship.
64.
It is of
The date is 15/3.
15/3/2016.
So 30 days will expire when?
On 14/4/2016, Your Lordship.
Okay. Yes, anything else?
Yes, now the legal issue is, Your Lordship, that writ petitions, Your Lordship,
Are not maintainable.
are not maintainable. The judgment, I have the judgments, Your Lordship. And secondly, Your Lordship, the petitioner was not a commercial concern. He was an industrial concern who had let out his premises to commercial concerns. So that was the catch. Now he is saying the projected case is, in the pleadings, Your Lordship, is that I had applied for change of category from industrial to commercial. First,
Mr. Sahewala, this court is going to first decide on the maintainability of your writ petition, because it appears there is a statutory appeal provision 127. Now, if on that basis this court disposes of, then perhaps any discussion on the merit of the matter might be prejudicial later on if you have to. We may say that you may file an appeal and these matters can be heard by the appellate authority. We can give that liberty if required.
Yes,
My lord, last time also, my lord, that
yes. Last time, Your Lordship, when this matter was heard, the previous officer, the person who was holding that post, he had retired. So now a new person is holding. I had placed an instruction that there was nobody holding that.
Think over. I'll just resume in 5 minutes.
Now he has been appointed.
All right, I'm resuming in 5 minutes.
Thanks, sir. Pass over to
Alternative remedy.
Alternative remedy. Here the facts were that the petitioner, the consumer in that case, Lordship had indulged in theft of electricity. So 3 issues were decided: whether the assessment procedure under 126 would also include cases of theft of electricity. So that was decided that yes, it would also include theft of electricity, because that also amounts to unauthorized use of electricity. The third important issue, Your Lordship, is when the appellate authority is provided under 127, whether a writ petition will be maintainable, Your Lordship. The relevant paragraphs, Your Lordship, is paragraph number 26, Your Lordship, from paragraph number 26 onwards. Starts at page number 2021.
Yes.
In the present case in hand, the petitioner challenged the final order passed under subsection 3 of section 126 of the Act of 2003, along with the other consequential reliefs. The issues decided herein above shows that the final order passed under subsection 3 of section 126 of the Act of 2003 also include the one against unauthorized use of electricity, where there is an allegation of theft of electricity under section 135 of the Act of 2003. Subsection 1 of section 126 of the Act of 2003 authorizes the assessing officer initially to raise the provisional assessment to the best of his judgment the electricity charges payable by the consumer after the inspection. Subsection 3 of section 126 of the Act of 2003 allows the affected consumer to be heard, and thereafter the assessing officer is required to pass a final order of assessment. In the present writ petition, as herein above taken note, the petitioner disputed the provisional assessment and the final assessment order on the ground that there were no cogent reasons or grounds to impute the petitioner upon unauthorized use of electricity with dishonest intention. Accordingly, the issues raised in the petition are factual in nature, coupled with the technicality of the metering system in the premises of the petitioner. Section 127 of the Act of 2003 allows any person aggrieved by the final order made under Section 126 of the Act of 2003 to prefer an appeal before the appellate authority prescribed under the said section. From the submission of the learned...
In this case, as regards the first contention of the petitioner is concerned, this court is not with the petitioner on that count. That is ultimately a jurisdictional issue, right?
Lordship.
That can be decided by this court. There is no difficulty.
Lordship.
Because according to this court, that 30 days time is not a mandatory requirement. That is primarily given with the aim that the petitioner shall have some window to file the objections.
Yes, sir.
Correct? The idea is that the objections they get a time, sufficient time for filing an objection, and the authorities, after going through the objection, will pass the final order. Basic idea is that here they have filed 3 objections, 2 within 30 days and 1 after 30 days.
Yes.
That is after the 30 days time is over. So now they can, and in that they have not objected. They have not said that you are stopped to pass a final order. In fact, they had asked for a review.
Yes.
So therefore today they are stopped to raise that. So this court is clear as far the first point is concerned. Prima facie, right now they of course have a right to reply. Second point, perhaps is a bit disputed facts are involved. Now that this court may have difficulty in, otherwise there is no point of sending this matter back because it's an old matter.
Yes, Your Lordship.
So, as regards the second issue, perhaps factual findings and facts would be required.
It will be required. It will be required, Your Lordship. Because their contention is, just in a nutshell, what they have projected is they were an industrial concern who had applied for a commercial connection. And their projection is that we were sitting over the application, and in the meantime they were caught using it commercially.
But
during an
later
inspection.
on, that commercial has been changed to industrial.
No, it was industrial. It was always industrial. Two things are.
No, what is not clear is this relates to those two Godams, right?
Two Godams.
Which were invited through advertisement,
Yes.
and then they entered agreement.
Yes, Your
Isn't it?
Lordship. Yes.
2014.
Yes, Your Lordship.
Correct. Now, at that time, the use was industry. Industry. And in terms of the notification, that MSC notification that has been given, that shows manufacturing Godam falls under industry.
That, Your Lordship, is under a completely different act. That is for the classification of industries into micro, small and medium enterprises. Here, when they were
Under the Electricity Act,
there is no such.
Do you have any guidelines as how you decide what is an industrial use, what is a commercial use? How is that given?
Your Lordship, high tension consumers, Your Lordship, beyond a certain wattage, kilowatt, they are all classified as industrial consumers. And then commercial usage, on usage, Your Lordship. And domestic consumers are domestic consumers who use it for their personal capacity. Industrial consumers are.
This is relating to the factual aspect.
Yes. Now, the projected case by them is that they had applied, but we could not find any application. And in fact, in the objections that they had filed, they had themselves admitted that we could not apply because we had area dues. And in the writ petition, they have turned around and said that yes, we had applied, and they have in fact annexed the application also. But that application, there is no when it was received, whether it was received at all.
So that is why I am saying it
Yes.
involves some factual.
It will require some factual
questions
determination, Your Lordship.
Also.
Yes, Your Lordship.
Yes. Anything else?
And Lordship, this judgment of the coordinate bench went before the division bench also.
Upheld?
Upheld, Your Lordship. And something was added to it as well.
In your favor?
Perhaps so, Your Lordship.
Yes. Where? Which paragraph?
Paragraph number 9, Your Lordship. After considering the
This is what this court wants to do.
Yes,
Because
Your
it's a statutory remedy after all
Yes,
provided.
Your Lordship. And in fact, even issues of due process, the division bench held that the appellate authority is competent to even adjudicate issues of due process also, Your Lordship.
Yes, Mr. Sahewala.
Just one aspect more, Your Lordship. This matter had once been disposed of by sending it back to the appellate authority earlier. Then at that time also, the appellate authority had demitted office. And then after a review was filed, this matter was restored. On the last occasion, the coordinate bench was inclined to send it back again. So I was asked to take instructions.
Are they reflected in the orders?
Perhaps so, Your Lordship. Perhaps it, not the around 2 hearings back, Your Lordship. But presently, Your Lordship, the present status is that the appellate authority. Presently, Your Lordship.
Are you referring to the order of 24/4/24?
Yes, Your Lordship. Yes. He has again been appointed, Your Lordship, and my submissions on instructions are recorded in that order, Your Lordship.
Where now there is an appellate authority.
Now there is an appellate authority. He has again been appointed. He has assumed charge with effect from 10th of June, Your Lordship.
No, if this court has to send it back, then this court will give a time frame.
Yes, Your Lordship.
Because this matter is pending from a long time,
Yes,
and
Your
it appears that already once this matter was sent back,
Yes, Your
and it had to be reviewed and restored
Yes,
because
Your
of non-functioning of the appellate
appellate
authority. That cannot be.
Yes, Your Lordship.
Mrs. Sahewala?
My Lord, first thing, my Lord, if the order is without jurisdiction, in that case, my Lord, your lordships can decide.
The exceptions are well founded.
Your lordships may see page 73.
You are saying it is without jurisdiction
because it is beyond time.
So that on that this court is not with you, Mrs. Hariwala, because that 30 days is this court doesn't find is a mandatory. It's a purely procedural. The decisions this court will distinguish. The income tax authorities, those this court shall. But that is what I am saying. If I have to go into all this, then later on it might prejudice you. Rather, it will be probably proper if I simply send it back with giving a time frame. Now, if you want, I will decide it. I think that probably would be, because since how much time?
Lordship, because it's an independent statutory authority again.
No, you see, Mr. Pathak.
Lordship, because I'll only be one of the.
No, correct. But you see, why the court wants to give a time frame is considering that about the retirement and all. That cannot be. We cannot keep the matter.
Lordship exercises all supervisory powers over that authority, Lordship.
No. You see, we can't keep it at a limbo where again tomorrow someone retires and they have to come back to this court. That cannot be a situation.
60 days perhaps should be.
So I'm giving a time frame.
Very well, Your Lordship.
60 days. 60 days, Mrs. Hariwala. Let them dispose of the appeal.
My lord, we have already deposited 30%, my lord. We should not be asked to deposit more, my lord.
Under the Act, something is...
That is a mandatory.
How much?
50% is
50%,
mandatory.
but this honorable court has given very less, my lord. In many cases, 25%. And in one case, my lord, it is less than 10%, my lord.
Show me. Yes. This I may say that 30% is sufficient and let them do it.
Yes. What?
Mr. Pathak, the statutory appellate forum has also been not functioning. The petitioner has also been suffering, rightly or wrongly.
From 16 onwards, we are suffering, my lord.
Correct.
Lordship, just one aspect, because this is the provision, Lordship, I'll just take a Lordship.
Which is the provision under which this has to be...
because the provision starts with, it's very uniquely worded, Your Lordship. 127.2, Your Lordship. Because that will amount to, Your Lordship, perhaps...
Shall be entered unless an amount equal to half of the assessed amount is deposited.
Yes, it starts at no appeal shall be entertained, Your Lordship. Because it's a mandatory provision.
This decision that you have just given me is on this point.
Your Lordship, yes. Paragraph number 30.
One sec.
Other decisions also, but this is a decision, my lord, here. The amount is, my lord, 6 crore, rupees 6 crore 50 lakhs at page 3. And we are directed to deposit 35 lakh only, my lord. Last page.
What is this?
Well, this is the order, my lord. The assessment was 6 crore 50 lakhs at page 3, my lord.
No, the 7624?
Oh, sorry.
Oh, this you had given. The appellate
yes.
Alright, let me start with the order. We will see that. What is that?
No, that order, Justice Suman Syam, my lord.
Okay.
So 8 years has already lapsed.
My submission in that regard would be that since this is a mandatory provision and the word shall is used, then perhaps that requirement of depositing 50% of the assessed charges cannot be bypassed.
We have many others. I have not brought
Heard Mr. G.N. Chayawala, Leonard Senior Counsel, assisted by Mr. S.K. Kejriwal, Learned Counsel for the petitioners. Stop. Also heard Mr. K.P. Pathak, Learned Standing Counsel, APDCL. for the state respondents. Stop. By preferring this petition under Article 226 of the Constitution of India, the petitioner is challenging inter alia the impugned notice dated 11/3/2016 and the provisional bill dated 15/3/2016 and the impugned final order dated 16/6/2016. Stop. The brief facts of the case is that the petitioner company, who is in the business of cold storage since 2001, for which they have industrial electricity connection of 82.41 kW, stop. The petitioner, since had some extra space in its premises, applied for commercial electricity connection on 9/11/15 and 16/12/15, and thereafter from 15 to 16 they entered into lease agreements with other parties, and on its persuasion for commercial connection, the respondents Thereafter, an inspection was carried out on 5/3/2016 by the respondents, whereafter a connected load report was prepared. Stop. Next para. Pursuant to such inspection, a notice was served upon the petitioner on 11/3/2016 to show cause as why they should not be penalized for using electricity other than what it has been provided for. Stop. The petitioner submitted reply to the respondents The petitioner accordingly submitted their response. Stop. After the show cause, this provisional assessment is done.
After the show cause, the provisional assessment was done on 15/3/2016.
No, I think
that is
after show cause and hearing, my lord. That is given, my lord, on one portion.
As I've understood, you delete this last paragraph. Inspection rakha. Pursuant to inspection ma kolona kiba ta report banaise. Tar pisor khini kati dia. Hetu kati dia. Hetu kati dia. Okay? Now you write. Pursuant to such inspection, provisional assessment was done on 11/3/2016.
On 15/3/2016.
No, what is this Annexure 6? A notice was given.
That is a notice of disconnection, Your Lordship.
Okay. No, but this disconnection has been stayed.
Disconnection, my lord, we have, yes, that has been stayed, my lord. And we have
First, a notice for disconnection of the electricity to the premises of the petitioner was served on 11/3/2016. Stop. Subsequent to such notice, on 15/3/2016, provisional assessment was carried out, and the same was furnished to the petitioner by letter dated 11/3/16.
15/3/16.
By letter dated 15/3/16. Stop. The petitioner filed their objection against the provisional assessment bill by their representation dated 30/3/2016, 12/4/2016 and 25/4/2016. Stop. Thereafter, by order dated 16/6/2016, and after hearing the parties, final order on provisional assessment bill was issued by letter dated 16/6/16.
Yes, 16/6.
By letter dated 16/6/16. Stop. The aforesaid final bill is under challenge before this court under article before this court. Stop. Mr. G.N. Sahayawala, learned senior counsel, submits that the impugned final bill dated 16/6/2016 is illegal, as the same has been passed after the expiry of the 30 days period stipulated under section
125(3).
Under section 125.
126(3).
120 under subsection 3 of section 126 of the Electricity Act 2003. Stop. He further submits that the manner in which the assessment has been made is also contrary to the provisions of subsection 5 of section 126 of the said act. Stop. Mr. K.P. Pathak, learned standing counsel, APDCL, on the other hand, submits that this writ petition is not maintainable in view of the statutory appeal provided under section 127(2). 127 under section 127 of the said act against an order passed under section 126 of the act.
Final order.
Against the final order passed under the provisions of section 126 of the act. Stop. Heard the submissions made at the bar and perused the materials available on record. Stop. Before entering into the merits of the contention raised by the learned counsel for the petitioner, this court is taking up the issue of maintainability first. Stop. Section 127 of the Act is reproduced hereunder for ready reference. It appears that the Act has provided an appellate authority before whom an appeal against an order made under section 126 can be filed. Stop. In view of the statutory appellate remedy available to the petitioner, this court is not inclined to exercise the discretionary equitable remedy provided under Article 226 of the Constitution of India. Stop. Reference is made to the decision of the coordinate bench of this court in Shiv Alloy Steel versus Assam APDCL and others, reported in 2021 4 GLR 558. Paragraph 26 of the aforesaid judgment is reproduced hereunder for ready reference. Stop. In the case in hand, the matter involves factual disputed questions which requires the technical expertise to decide. Stop. Hence, this court is of the opinion that this writ petition is not maintainable. Stop. Mr. K.P. Pathak, learned Standing Counsel APDCL, has also furnished a copy of the notification dated 7/6/2024, which indicates that the appellate authority under section 127 of the Act is functioning. Stop. Where is the division you have given? Yes, I got it. Intermediate 26 paragraph to Tolot Lekha. The aforesaid decision of the coordinate bench was further upheld by the division bench of this court in WA 286 of 2021. The last paragraph, accordingly, this court is of the opinion that the remedy available to the writ petitioner under section 127 of the Electricity Act being available, this petition can be disposed of with the direction that the petitioner will have a liberty to place all his points before the appellate authority, statutory appellate authority. Stop. Accordingly, let the writ petitioner approach the appellate authority for redressal of his grievance in terms of section 127 of the Act. Stop. There is no time limit, right? And in 127, no time limit.
30 days. 30 days.
Time limit is there?
You can file. Then time limit for filing an appeal.
Yes. In view of the tendency of, in view of, since this petition has been filed before this court against the order under 126, of the said Act, the time limit, the stipulated time of 30 days as provided under subsection 1 of 127 shall not be insisted, provided the petitioner files the appeal within
30 days from today.
30 days time from today. Stop. Further, in view of the fact that the petitioner has already deposited 30% of the assessed amount, and considering the fact that at the time when the writ petition was filed, there was no appellate authority functioning, this court as an exception provides that the provision of subsection 2 shall also be not insisted at the time the petitioner avails the said appellate appellate remedy. Stop. Reference, let me also refer to that decision. Within bracket you say reference is made to the decision of this coordinate bench in the case of APDCL versus MM Concast in I Civil 3030/2019 in this regard. Close brackets. Accordingly disposed of. In view of the above, the petition is, with the observation and direction, the petition stands disposed of. I have said as an exception.
Yes.
If you want, I can also clarify that this is only in the facts of this case.
Perhaps some because otherwise, what happens?
Needless to clarify that the concession given are only in relation to the peculiar facts and circumstances of this case, and the same shall not be binding in relation to any other in other proceedings. Same shall not be binding in any other proceedings.
Deeply observed.
Tumak ba lagibo, Electricity Act lagibo, and the decision to lagibo. I'm giving you everything, huh? You take the decision dictation just, and at the end you say that a copy of the notification dated 7/6/2024 furnished by Mr. K.P. Pathak, learned SC APDCL, is kept on record and marked as X. Sharmila? It will mark it. Mr. Sahaiwala, Mr. Kejriwal, I think Mrs. Sahaiwala's book is with me.
Yes, yes.
After she types the order, you take it back from the court master. Ask one of your junior.
Yes.
All right. Yes. Item number 58 disposed of. Huh? Item number 18. Yes.
May I please your lordship? In this matter, I am appearing.
Mr. Deka, for which matter you've been jumping around? All right. Wait. Yes.
Lordship, I am appearing for BTC lordship.
Item?
Item 18.
18.
18 lordship.
Yes.
Here we have received one notification from the BTC that BTC authority has no role to play here, only to provide the compensation amount if they have deposited to us, Lordship.
Ms.
This
Bora,
was-
I cannot understand
Lordship.
what you're submitting. Please
Lordship.
speak a little loud.
Lordship, they have to follow guideline of Union of India, Lordship, and Power Grid has to assess the amount and pay the amount to them, Lordship.
So they basically have to submit it in a prescribed format.
Yes, Lordship.
In terms of the guidelines.
That has to be followed by the Lordship. BTC has no role here, Lordship.
But who is appearing for the Power Grid?
Power Grid?
You are?
I am appearing on behalf of MSK Bhupan, but my lord, due to medical emergency, she cannot come today. My lord, allow another date, my lord. Kindly allow another date.
Well, otherwise this petition can be disposed of in terms of this notification.
Lordship. But they have to assess, Lordship.
But her senior is not there. When can he be available? Otherwise, you have any objection if I dispose it in terms of this notification? That you, after verification, due verification, after pursuant to their submission of their claim in the prescribed format in terms of the guidelines, and after due verification, you release the payment.
My lord, kindly please.
Alright. As prayed for on behalf of
MSK Bhupan.
MS
K Bhupan.
A. Fukan, K. Fukan, comma, Learned Counsel for respondent number
3 and 4.
3 and 4. List this matter on immediate after vacation. Ms. Bora, you keep this. You give it on the next date.
Deeply.
17. Yes.
July. Oblige.
Handling item number 28.
Yes, what is this? Mr. Pathak, it appears there is a similar order.
Yes, Your Lord.
Have you gone through?
Yes, Your Lord.
Is it applicable?
From the case projected, it appears to be applicable.
No, if you agree, I will pass a similar order.
Very well. Order passed in WPC 4575 of 2021.
Yes.
Yes.
The operating part is at 25.
Yes, Your Lord. The directions are in 25.
It will be, everything will be same except.
Yes, my lord.
What about this order dated 29/8/16?
Impugn order, Lordship, it has been annexed at page 21.
No, this order, what is clause 3
Clause
of
3,
the
yes.
order
clause-
dated 29/8/16?
Yes.
Is that the same date?
Same, my lord.
Same date.
Same.
Everything remains same.
Yes, sir, same.
To disposed of for current day. Item 28. Heard Mr. N.P. Kolita, Learned Counsel for the petitioner, and Mr. K.P. Pathak, Learned Counsel, Learned Standing Counsel, Excise Department for all the respondents. Stop. By filing the petition under Article 2 to 6 of the Constitution of India, the petitioner is assailing inter alia a demand notice dated 9/5/2022 issued by the respondent number 3, whereby the petitioner has been asked to deposit the establishment charge as per demand notice with effect from March 2022 to April 2022 within 31/5/2022. Stop. It is submitted at the next part. It is submitted at the bar that the issue involved in this writ petition has already been is covered by the decision of the coordinate bench. Coordinate bench.
Yes.
Coordinate bench.
Of this court in the case of MS Barak Warehouse Private Limited and another versus the State of Assam in WPC 4575/2021. Stop. In view of the aforesaid endorsement made by the learned counsel for the parties, this court deems appropriate, in the ends of justice, for disposing of this writ petition with a direction that the instant writ petition is also disposed of in terms of the said order dated 9/5/2023, passed in WPC 4575 of 2021. Stop. Next para. Accordingly, the instant writ petition stands disposed of with the following observation and directions. 1, Roman 1, Roman 2, Roman 3, A. Asylum, and 4. Disposed of. Okay? I didn't record much because since it's a covered judgment.
Yes, appears to be similarly placed.
1, 2, 3. Disposed of. Tech change করে দিলাম, এটা disposal পাইছে। এটা কিমান আছিল 20? Yes, Mr. Deka.
Here the respondents have not filed their affidavit for 6 years.
6 years?
It's a repetition of 2018.
What is the issue?
My lord, during Rajiv Gandhi's visit in 1986, my lord, my premises were taken for occupation by the 2nd Battalion of the Assam Special Police Reserve, my lord. Now,
you have been deprived of your property
yes.
without any compensation
Nothing, no
made for the last 6 years?
Nothing.
Who has deprived you? Which department?
Not 6 years, but right from 1986 till 2006. 86.
Yes, government. Who has filed? There's one affidavit
There's
filed
one
by R5.
by the respondent number 5.
Who is R5?
R5 is the commandant of that particular battalion, my lord. He admits, my
Ms.
lord.
Borua, who is the concerned person who has to, concerned department who has to release this money?
My lord,
your cases for compensation?
Compensation or rent, by whatever name it's
yes.
called.
Which is the, by Mr. Deka, where is the order of taking?
My lord, taking order is not there. Page 30, the release order is there, my lord.
30?
30.
I am disposing of this petition, Ms. Borwa. It can't be. From 86, a person has been deprived of his property without the due process being followed. His basic human rights have been deprived.
Kindly pass about for timings as Siddhartha Borua is appearing. He is
all right. Timing this court will allow. Mr. Deka, wait for some.
Apply.
Yes, Mr. Banik.
Item numbers 43 to 46. There is a change of guard. I am appearing in this matter.
There has been?
I mean, the councils have changed.
You want some accommodation?
That would be. It will be after vacation.
Mr. Das?
Yes, Roger, I'll be on
Mr. S. Banik, learned counsel for the petitioner, submits that there has been, that his office has been recently engaged in the matter and accordingly seeks some accommodation in the matter. Stop. Prayer is not opposed by Mr. D.J. Das, learned counsel, appearing on behalf of the respondent.
The respondent.
The respondent. Stop. List this matter after 3 weeks on a date to be fixed by the registry.
Much obliged.
Grateful.
May it please your Lordship. Lordship, some petitioner has not yet furnished the undertaking, Lordship, for which the Jirat compensation could not be released, Lordship.
Sorry?
Some petitioners has not yet furnished the undertaking for which...
Undertaking?
Yes, Lordship.
For which the Jirat compensation
has
is
not been
awaiting?
Released. Yes, Lordship.
Yes.
My lord, why undertaking is required? Because whatever amount there, let them deposit in the bank account, my lord. Undertaking means I have no further claim. My lord, what they have assessed, we are not disputing right now, my lord.
Lordship, kindly the matter may be fixed after vacation. In the meantime, they may approach the respondent number 6, Lordship.
Without undertaking, we are ready to...
The others have already given the undertaking.
Others were pursuing them.
Mrs. Ananya, see, at the end of the day, the compensation, you are concerned with the compensation. So So if some undertaking is to be given, you give it, and I can otherwise dispose
No, my
it
lord.
with that direction.
My
But
lord.
you submit whatever undertaking is required. They will, and thereafter they will release it within the period of 2 months from the date.
My lord, receive amount I can give, my lord. I don't have any further claim, I cannot give because
what
they have
is
not
this
given the jirat.
undertaking?
They have not given the jirat, only the land value, my lord.
What is this undertaking that you
Lordship,
want?
if any court passes any order, Lordship, the petitioner is required to undertake that amount would be refunded, Lordship.
Where is that? Where are you reading it from? Is a part of?
No, Lordship, it is my instruction.
Okay,
So
okay.
I'm reading it from there. Secondly,
I can
Lordship,
issue
without
receipt,
any
my lord, no doubt,
obstruction,
my lord.
You see,
possession will be handed over
Mrs.
for that.
Harania, you take a call.
My
This
lord.
court is
My lord.
ready to dispose it with a positive direction in your favor,
My lord.
subject to, of course, following the formalities.
My lord. Only they are forcing that I no further claim. That too, I cannot foreclose the other
We will
claim.
file our affidavit. Meantime, they
All right,
may
you file your
approach-
affidavit then.
My
Lordship,
lord.
let them approach respondent
all-
number 6, Lordship.
That I am not saying anything. If they are not willing, they will not. As prayed by MS,
S. Kempra.
S. Kempre, London Standing Council, KAC, which is not opposed by the other side, list this matter after
After the vacation.
after 2 weeks on a date to be fixed by the registry to enable the KAC to file their affidavit in opposition in the matter.
My lord. I'll do.
All right.
Yes, any instructions was
Lordship,
required
this
from the
matters-
petitioner?
Become inspectors, Your Lordship.
Instructions?
Lordship.
Yes. Your name?
S. Das Gupta.
Heard MS
S. Das Gupta.
S.
Das Gupta.
S. Das Gupta, learned counsel for the petitioner. Stop. Also heard MS
J. Bora, Lordship, on
J-
behalf of S. Dr.
J. Bora, learned counsel for respondent number
Respondent number 1, 2, 3, 5 and 7.
1, 2, 3,
5
5
and 7.
and MS S. Borwa, learned government advocate for respondent number 4. Stop. It is submitted at the bar that the matter has become infractious. As the in view of the dissolution of the
No confusion.
concerned panchayat body.
Lordship.
Stop. In view of the aforesaid endorsement made by the learned counsels for the parties, this writ petition stand dismissed on being infractious.
Obliged, Your Lordship.
48 and 49 both?
Yes, Lordship.
40 and 49, huh? Both.
Obliged.
Butai dismiss, 48. Change corridor. Yes.
Your Lordship. Lordship, I have approached this court as I applied for one RTI information that was not provided to me, my lord. I had
Affidavits?
notice has been served, but they have not filed it. They are not appearing. my lord.
Who is appearing for the other side? 1, 2, 3.
Yes, my lord.
It appears from the office note dated 8/11/2023 that the service in respect of respondent 1, 2, 3 stands complete. However, when the matter is called today, none represents the respondents. Only 3 respondents.
Yes, ma'am.
On top you say you are K.R. Borwa?
Yes, ma'am.
Heard Mr. K.R. Borwa, learned counsel for the petitioner. Stop. All right, we'll take it up after vacation. In the meantime, if they come, they'll come.
Yes, my lord. Date may be fixed. my lord.
Let this matter be listed reopening on such and such date.
26 July.
I'll say for admission.
Admission.
For admission. Yes, item 53.
Yes, Lordship. May I please, Your Honor. In this case,
Yes, Ms. Borwa, you had taken time on the last occasion.
Affidavit is sent for vetting, Lordship.
MS S. Borwa, learned government advocate, submits that the draft affidavit in opposition has been sent to the government for vetting. Stop. List this matter after 3 weeks on a date to be fixed by the registry to enable the state respondent to file the necessary return in the matter.
May I appeal also? Item 36. I have taken consent. Let this matter come up after vacation, my lord.
36?
36. Timing matter.
At a time, alright. In item 36, as prayed for, list this matter after 3 weeks on a date to be fixed by the registry.
Obliged.
Take some time?
No, Lordship, just I have went out.
Because otherwise we only have 4 days, Mr. Sharma, left before the closure. We can have it after the reopening immediately on a hearing date.
I'll take not more than 10 minutes.
Because otherwise, you see, there's no point of closing it. There will be no time during this time. It's better I hear it, whatever has to be, because after your arguments, maybe Dr. Sharaf might also like to add something. And we can immediately give the judgment thereafter. So let's have it on a date fixed after the reopening, as convenient to you all.
No, as per Lordship, sir. Otherwise
That will be more convenient, in case it doesn't inconvenient any one of you.
It doesn't cause, but my lord, my turn was only for about 10 minutes.
I know, but piecemeal manner, Mr. Sharma, will really not serve any purpose to anyone. There are other matters also today which are waiting.
We have no difficulty as per Lordship's.
Yes, when can we have it?
Lordship, week commencing from 22, if Lordship not.
You can give me a date? Mr. Sharma,
Monday.
you will have to come from
Any
Delhi.
Monday,
Monday? Dr. Saraf?
But I have no problem with it, whatever Lordship may fix.
So please suggest a date. OP. List on such and such date for further hearing. At 2? Is 2 o'clock convenient? At 2.
On 22nd, my lord?
On 22, Lordship.
22nd, Dr. Saraf?
By Lord, at 2 o'clock.
On 22nd.
Obliged.
Very good. Grateful. Lordship will indicate its partner.
Yes, yes. Yes, Mr. Dekka?
No.
Mr. Borwa is here?
Yes.
Since when, Mr. Dekka, when was this land taken?
1986.
1986. For what purpose?
My lord, during Rajiv Gandhi's visit, my lord, for the law and order situation, they wanted to depute a battalion here, my lord. So, of the 2nd Battalion of the Assam Police Special Reserve Force, my lord, Company 2 was put here, my lord.
Deputed.
Yes.
And thereafter it was...
Thereafter they continued and we went on representing to them.
They continued till when?
Till 2015.
2015. And thereafter it was released.
Yes, my lord. Page
and
27.
For the period that they had taken your land from 1986 to 2015, no compensation whatsoever was given.
Nothing.
So this was requisitioned.
This was requisition, but it did not happen as per the procedure because there has to be a notice. Nothing of that sort was followed. They came and they took possession, and then we kept on writing and on.
Where are your representations?
Yes, my lord. Annexure B series. There's a Annexure A onwards, my lord. And eventually, Annexure A is a series of representations, my lord. And eventually, at page 27, your lordship will find we to ask them to vacate.
This is for vacation.
This is for vacation. Prior to that, we had been writing to them to fix a rent.
One second. Mr. Dekka, please come in sequence from the beginning.
Page 21 onwards.
Page 21.
This is the first representation on record.
But you see, your representation, Mr. Dekka, says the accommodation was provided to the police department as a gesture of goodwill and until a permanent accommodation for the battalion is arranged.
Yes.
We would appreciate that prolonged stay and usage so and so, fix as rent.
And then we wrote to
And
them.
this was dated?
This is dated 9/9/2009.
Where do you find the date?
On the top of the page, left.
Oh. 9/9/2009. Yes.
Then again on page 20.
The date is not reflected as on which date it was given.
No, Manoj,
that is not.
there. But there is an admission, Manoj. I'll come to that in the affidavit.
Then,
Manoj, page 23 is a similar representation requesting them to fix a rent. This is dated 2010-2009.
This is again for rent.
Yes.
Since 1986, the station at the said building, and it seems they are to also extend their status further period. Yes. Then
at page 25, this is another representation. Here we said, Manoj.
Yes.
With reference to the above, I have the honor to inform you that the occupation of the building as per our information took place in the middle of the year 1986, but the exact date is not available with us. During shifting of our office in so-and-so estate, the papers and records of the office were misplaced, and as such the same could not be located. However, we expect to claim rents from the 1st of January 1987, and as such request to treat the date of occupation from 1st January 1987 for absence of record at our hand. Now, then eventually at page 27,
yes,
we asked them to vacate. I'd like to inform you that we require the bungalow.
Then, what is this at 28?
Page 28 is another. Manoj, this is another request. We are reiterating our request to vacate the premises. 5/11/2015. Then, Manoj, page 30 is the possession handover.
Finally, they hand over possession.
Yes.
This is on dated.
This is on 15/11/2015.
After this, have you filed any representation?
After this, we've sent notices, and yes, a legal notice, and also we've annexed the PWD rates.
Where is that?
I'll show you. Page 30, first of all, if your Lordship sees once, they have admitted the occupation from 1986.
Where?
Page 30.
30?
I, Subedar so-and-so, in charge company commander of so-and-so,
Station from the year
1986 at LLB so-and-so.
This is admitted.
This is now 15 November, so 1986 till 15 November 2015, they were there.
So this is page 30, admitted position.
Yes.
Yes, please show
Then,
me.
page 32 is the report by this evaluation estimate by the executive engineer PWD.
Yes.
Now here, Manoj, with periodic enhancement, the rent for each 5 years has been calculated. Then, Manoj, we wrote to the at page 51, Manoj, we raised the bill. At page 50.
So you are basically for release of this bill.
This release.
This is your
bill.
grievance
Yes,
right
yes,
now, isn't it?
Yes. And the battalion commander says that we page 51 I raised the bill, Manoj.
Yes.
Page 54 is the reply.
1 second. 2616 is your bill.
Yes.
Yes. Then?
And at page 54 is the response from the commandant. May I read this?
Yes, please.
With reference to the subject above, I am to inform you that the bill submitted by you could not be entered in at this end because we are only deploying authority of battalion personnel under the district administration on receipt of requisition. Only Deputy Commissioner and Superintendent of Police are responsible to provide accommodation for utilizing our force at their end. Accordingly, management of accommodation have been made from district administration, that is whether the Deputy Commissioner or by the Superintendent of Police, so that the bill submitted by you is returned herewith and request you to move the proper authority.
So according to them, it is either the Office of Deputy Commissioner or SP.
Yes, yes.
Who has to...
Yes. Then I eventually issue a notice. Since that did not elicit any response, we filed the writ.
Where is Mr. Borwa?
Yes. He is on court number 13. He will come after this.
No, because I am thinking of disposing of this writ petition with a direction to the office of the DC, or probably DC only, isn't it?
DC.
The office of the DC to verify the claim of the petitioner and dispose it off within the period of 1 month from today.
Yes, that's it.
I think that is going to be a fair order. He's been waiting from 2016.
Yes, that's
and
it.
admittedly, the premises of the petitioner was used for the battalion force.
Yes, that's it.
Isn't it?
Yes.
That's an admitted position. They have agreed.
Yes.
So it cannot be that his property will be used and nothing is going to be also given.
Yes.
I think that would serve your purpose, Mr. Deka, because otherwise, you see, you may have got a verification and submitted the bill, but that quantum, the office of the DC may agree, may not agree. This is for them. Let them verify.
Yes, that's it. Yes, that's it.
For disposal, Heard Mr. B.D. Deka, Learned Counsel for the petitioner. Stop. Also heard M.S. S. Borwa, Learned Government Advocate for. Is revenue or anyone there? No. Only state government, Mr. Deka?
State, the Deputy Commissioner, the Director General and the Superintendent.
So state government.
State government.
For the state respondents.
Respondents are also there. Performer respondents are there.
That's all right. Stop. By filing this petition under Article 226 for the Article 226 of the Constitution of India, the petitioner is seeking inter alia direction for payment of a sum of rupees 49,34,400 to the petitioner as the compensation for the use and occupation of the petitioner's premises. Stop. The case of the facts of the case is that the petitioner is the owner in respect of one Assam type building bearing holding number 172 situated at LB Mills compound, Surendranath Roy Path, ward number 1, GD Road, Golaghat, Assam, on the land covered by DAG number 5851 pertaining to periodic patta number 1117, within brackets, hereinafter referred to as the said premises. Next paragraph. The said premises was delivered to the Golaghat district administration as a goodwill gesture at their request to provide accommodation and utilization by the police personnel during the visit of the former Prime Minister of India, late Rajiv Gandhi. Stop. It is the specific case of the petitioner that the district administration had promised that they would pay consideration on account of occupation and utilization of the said premises and deliver vacant possession of the same whenever required. Stop. Accordingly, the said premises had been under occupation and utilization of the ASRF, BN-2 personnel since 1/1/1986 onwards. Stop. Stop. Though various representations have been filed to the district administration for payment of rent for the use of the petitioner's premises by the ASRF battalion personnel, no rent whatsoever was paid to the petitioner. Stop. Later on, pursuant to such representations for payment of rent, the petitioner also represented before the district administration for vacating the premises and handing over the possession back to the petitioner. Stop. However, the same was not done. Finally, this was given back on 15/11, na?
15/11/15.
Finally, on 15/11/2015, just calculate the years. After almost so many years, the officer, the police officials, right?
Yes, yes.
The police officials, the jurisdictional police official,
Company commander.
Where are you getting all this?
On page 30, there's a
Yes, yes. The seal.
The seal.
It's not very clear.
It says Company Commander, ASRF BN2 Bikoi.
One sec. The company commandant, ASRF, BN2, B-Koi, headquarter, handed over the possession of the said premises to the petitioner. Stop. After taking possession of the said premises, the petitioner submitted the valuation estimate of the said premises to the Executive Engineer PWD, Jorhat Building Division, Jorhat, by letter dated 7/6/2016. Thereafter, the Executive Engineer PWD, Jorhat Building Division, they submitted. It starts from where? That the valuation report which you had relied.
Page 32 onwards.
30?
2.
Valued the aforesaid, valued the said premises. Stop. in terms of the aforesaid valuation, comma, the petitioner served a bill for amounting to rupees
40. On page 51.
Yes, where is the total? 49, 34, 400 to the Commandant, Second ASRF, BN, Karagaon, Karbi Anglong, Assam. Stop. The said authorities by letter dated 26/2016 informed the petitioner, sorry.
Page 54.
The said authority by letter dated 5/7/2016 returned the said bill to the petitioner by directing them to move it before the proper authorities, i.e. the district administration. Stop. Since 2016, the petitioner has been representing before the district administration for release of the bill in connection to the use of the said premises. However, since no payment has been received, comma, the instant writ petition has to be filed, is being filed. Stop. Heard the parties and peruse the documents, peruse the materials available on record. Stop. It appears from the possession certificate dated 15/11/2015 that admittedly the petitioner's land has been used and has been in the possession of the ASRF BN-2 Bikoi headquarter from the year 1986 to 15/11/2015. Stop. It further appears that it is at the request of the district administration that the petitioner had given his land to be used by the aforesaid authorities. However, admitted position is that no payment whatsoever has been made by the district administration in this regard to the petitioner. Stop. This court is of the considered view that this writ petition can be disposed of with a direction to the district administration to verify the claims of the petitioner and do the needful in accordance with law within a period of 1 month, 2 months,
3 months.
Within a period of 2 months from today, from the date of receipt of the certified copy of the order. Stop. Mr. Borwa, should I say, should I ask them to file a representation or verify their claim?
Verify the claim.
That will be appropriate. Needless to clarify that the petitioner shall submit a copy of the writ petition along with other relevant papers to the office of the district administration within a period of, along with a copy of the certified copy of the order of this court for doing the needful. Stop. I think that will then everything will be before the district administration.
After the verification,
I have mentioned, I have said.
Will your Lordship say verify the claim or calculate the dues, my Lord? Because admittedly I am entitled to something, my Lord. Then
the verification would be appropriate because it
Verify the claim, Mr. Deka, is the appropriate word, because you see, there is one thing here. Now, admitted the possession certificates are being issued by the army authorities. Correct.
Yes.
They are not before this court. Now,
They-
how they took it?
No, they're there. They filed the affidavit also.
They have filed.
They filed the
Where
affidavit.
is that affidavit?
Commanded.
Where they are a respondent here.
Respondent
R5.
R5. R5 is saying, my lord, even at page 37, your lordship has seen, they are saying that we have been occupying, but this was at the behest of...
Which part of the parent affidavit? Because you see, I was initially thinking of putting an observation
Yes.
as regards your deprivation
No, no.
for the use.
Yes.
But then only thing, it's not clear to me, that's why.
Page 54, once if your lordship sees of the writ.
Yes.
Page 54 also they are admitting, they're
That
just
I have
passing
seen.
on the liability towards the district administration.
OP, where I have where I am saying after the hearing the parties towards the end, it appears that they are army officers.
The police officer,
The-
Assam Police Special
the
Reserve.
Assam Police,
Assam Special Reserve.
Assam Special Reserve Force,
Yes.
that the officers of the Assam Special Reserve Force, within bracket respondent number 5, both in the affidavit in opposition filed on 2/6/2022 and in the letter dated 5/7/2016 has admitted the factum of possession of the said premises and have informed the petitioner that their bill could not be entertained at their end because they are only deploying authority on receipt of requisition, and it is the office of the Deputy Commissioner and Superintendent Police who are responsible to provide accommodation for utilize of their force at their end. Stop. Accordingly, they sent back the bill of the petitioner dated 5/7/2016 to submit before the said authorities. Stop. Okay? Then you say, now you read that last paragraph. And then, add one more paragraph. Add one more.
And in fact,
The right of the petitioner over the right of the petitioner to the said premises, though is not a fundamental right, but the same is a constitution, statutory and human right. Stop. The same cannot be deprived by the authorities without following the due process of law. Stop. Admitted in the present case, it appears that the land, that the said premises of the petitioner was utilized for the officers of the Assam Reserve,
Special Reserve Force.
Assam Special Reserve Forces at the request of the district administration for the last such and such years. I want that year.
29 years.
For the last 29 years, and not a single penny has been paid as rent to the petitioner. In fact, it is averred in the writ petition, to which there is no rebuttal from the state authorities, that during the aforesaid 29 years, the petitioner has spent huge amount of money in repairing. You have said that, right?
I've said that.
In repairing the said premises. So, reference is made to the decision of the Apex Court in 2013 volume 1 SSC at page 353 in the case of Tukaram Kana Joshi versus Maharashtra Industrial Development Corporation and others. Stop. Paragraph 9, paragraph 8 to 12 of the aforesaid judgment is reproduced hereunder for ready reference. Stop. Next. It is regrettable that the state authorities have taken over the land of the petitioner, has taken over the said premises of the petitioner for the use of the ASRF for the last 29 years and has not paid any rent stroke compensation to the petitioner in this regard. Stop. This is a sheer violation of the constitutionally guaranteed right to the petitioner. Stop. As such, the writ petition succeeds. No, I'm giving it, that part you remove. Accordingly, this court is of the considered view that the bill dated, where is the bill? Bill dated 20 June 26, 2016, amounting to rupees 49,34,400, after verification, be released by the office of the respondent number, by the respondent number
123,
by the respondent, by the respondent numbers 1, 2, 3 and 4 within a period of 2 months from the date of receipt of the certified copy of this order. Stop. Disposed of. Needless to clarify that a copy of the writ petition along with the certified copy of this court's order be furnished by the petitioner to the office of the respondent authorities for doing the needful.
I had a claim for interest as well,
Mr. Deka,
I'll leave it at that.
I think it is better you leave it here.
Obliged.
We are still not sure what they will come and do. Alright? Disposed of.
Obliged.
Rupa, এটা সুপ্রিম কোর্টের ডিসিশন পে বলবো এটা জিজ্ঞাসা আদাস Yes, this is item 11. Yes.
The proposal will be coming, but by that time, our Lordship may kindly peruse their affidavit. This is filed by Finance Department, paragraph 3.
Of page?
Page 26.
Yes.
The Government of Assam in the Finance Audit and Fund Department issued an office memorandum bearing number so-and-so dated 29/7/2006. In the said office memorandum dated so-and-so, it has been provided that the families of state government employees, home guards, personnel of army and central paramilitary forces engaged in counter-insurgency operation in the state, if killed while on duty or in connection with discharge of duty, as also the families of the driver, handyman and other employees of the vehicles requisitioned by competent authority for law and order and other emergency duty, if killed due to attack of extremists or antisocial elements. And
you are not entitled.
That is why.
You are the petitioner's son was a school teacher.
Yes.
How are you saying that you are entitled in terms of OM 6696? Yes, how? Show me.
May I please, Lordship? Lordship, my senior lacks in another court. So my lord highly organized.
Tomorrow then?
Man.
Kindly list correct. List it as prayed for. List tomorrow.
Much obliged.
Highly organized.
Please, Your Lordship.
Yes.
I am for respondent number.
Today is the returnable date.
No, my lord, actually, returnable date has already passed, I think.
Huh?
Today is not the returnable date.
No, do you want to file something?
No, I have already filed my FDI opposition.
You have filed?
Yes, I am for respondent number 9, 10 and 11.
You have 9, 10, 11?
Yes.
And what about state? Alright, then you file it. MS S. Borwa, Learned Government Council submits that the draft affidavit in opposition has been sent for vetting to the concerned department. Stop. Accordingly, she seeks accommodation in the matter. Prayer is not opposed. List this matter
After vacation.
after 3 weeks on a date to be fixed by the registry.
Sir, date may be fixed, my lord.
Don't worry, after 3 weeks it will come.
Okay.
Yes.
May I please, Your Lordship? Lordship, this is contempt petition. Here, Lordship, as per office note dated 19/6/24, the
await service.
Yes.
Await service report in respect of
respondent number 2.
Respondent number 2.
Yes.
List after 3 weeks on a date to be fixed by the registry.
Lordship, deeply obliged.
But as per instruction of my petitioner, some process is going on from the side of respondent. My lord, shortly, I hope, my lord, they will comply with the order. So, my lord, the matter may again be taken up after summer vacation, so that within this time, my lord, if the order is fully complied with, my lord, the matter can be.
Lordship.
Yes.
Lordship, I'm appearing for both the respondents in this matter, Your Lordship. Lordship, I've received an instruction. There it is stated that the circle officer Bilasipara, who is the respondent number 1, has taken steps as per the instruction from the Deputy Commissioner as well as the direction passed in the Honorable High Court's order. So, Your Lordship, thereafter, a hearing was conducted, Your Lordship, on 23rd of May for the disposal of
Order is complied.
the presentation of Your Lordship. They are requested to deposit some money, Your Lordship, premium. Thereafter, the land records will be corrected as per the instructions. Lordship, I will file my affidavit,
File
Your
your
Lordship.
MS N. Bordul, Leonard, the council for respondent for the contender number 1 and 2 has sought 2 weeks' time to file the necessary return in the matter. Prayer is not opposed. List this matter after 3 weeks on a date to be fixed.
If I may pray for a fixed date, because I
List
won't be available.
to give a date after vacation.
I won't be available that week, either prior or
After.
or August 1st, 2nd, 3rd of August. Saturday, okay. I'm deeply obliged.
All right. Rupak, 42 to dispose of Nikki somehow. We're good? Anything, Ms. Bordler?
5th of August.
All right.